Check, check, check.
This is a test from the push-to-talk system.
Recording in progress.
We're testing. This is Alejandro on the left side. Testing. Alejandro, English, 1, 2, 3.
Testing. David Schmidt in English, 1, 2, 3. Testing, testing.
Testing. Alejandro Alcántara, 1, 2, 3.
Good morning, everyone. I think I pressed the wrong thing. Okay. Good morning, everyone. Yes, I am. I was shifting. Yes. Volume okay. Yes? Thank you. Good morning, everyone. It's good of you all to be here this morning. We are now going to commence the hearing number 1 of this 186th regular session of the Inter-American Commission of Human Rights. And the hearing is entitled Right to Information of Relatives of Victims of Enforced Disappearances in the Region. And it was requested by the Fundación Hasta Encontrarlos, Colombia, and Association of Families of Disappeared Persons, as FEDES, yes, Colombia, and others. I think I'm not going to murder your names any further. And we all know, well, perhaps you can just mention your names as you speak. My name is Margaret May Macaulay. There was an election last night, and I was elected the president, and my learned sister on the right is the second vice president of the commission presently. And on my left is the immediate past president of the commission. And we have also present Commissioner Strado Vallon and the Executive Vice President, Tanya Rolon, and special rapporteur for freedom of expression, Pedro Vaca. Yes, my head is not quite straight this morning. It was a long evening yesterday. And of course, I beg your pardon, Mr. Deputy Secretary of Petitions and Cases, Mr. Jorge Mesa. So we commence. Sorry, Maria. And we also have Deputy Executive Vice President Maria Claudia, who is the stalwart and the vault of knowledge of the Commission. Yes. We start by welcoming you again to this hearing, and we hope we achieve the purpose of the hearing of your request. We are going to distribute time in this way. For you, civil society, you will have 22 minutes initially. And our guest expert, I beg your pardon, Ms. Senor, I should have referred to you earlier and introduced you earlier. We have a guest, a member of the Office of the High Commission of Human Rights, the Mexico office, who is with us here today and will make a joint statement. He is Senor Guillermo, I made you feminine, I'm sorry, Fernandez Maldonado. Thank you. And he is in the UN Committee of Enforced Disappearances and the Working Group on Enforced and Involuntary Disappearance. So you will have 22 minutes. You, Mr. Senor Maldonado, will have 8 minutes, and the Commission will have 22 minutes, and then we will have 20 minutes back to you, and we will close in 3 minutes. And we hope we will be on time because we have so many hearings set for today. To present the target audience is that you will present information on the challenges faced by relatives of forcibly disappeared persons in the countries of Colombia, El Salvador, and Guatemala, in the absence of information on the fate and whereabouts of missing persons, and particularly in accessing information held in confidential and/or military archives. So, with that, I invite you to make your presentation. Thank you.
Good morning, everybody. We want to thank this Pablo Cala, defender of human rights and Fundación Hasta Encontrarlos. We want to thank this commission for calling to this hearing, a hearing on access to information, or reserve information, military records, which is connected to the right to information. We think there's an important precedent, and we're going to have the Committee Against Enforced Disappearance Committee from the UN and the work group, along with the High Commissioner Office from the UN. So that shows the interest you have expressed in your multiple agreements about this commitment to stop these enforced disappearances. Present in this hearing are men and women that we see here in these pictures. Not only that, but all those who are following this transmission, this broadcast at home, their families of a lot of missing people from Colombia, El Salvador, Guatemala, and other parts of this continent. These are men and women who have disappeared enforceably because they think different, they feel different. Not only were they arbitrarily detained and tortured and assaulted sexually, all this is because of the impunity of this enforced disappearance. We hope this hearing to open ways, to open roads, to guarantee the right we all have to information, which can provide us information about the whereabouts of these missing people. In many cases, 50 years old, others over 70 years that they disappeared. We hope that this hearing will give hope to the families and also present an answer by the multiple states. So our participation is marked by the question, where are the missing people? Where are these disappeared people? And the continuous fight against impunity, being so hard to find information that will take us to determine whether the military made them disappear and find that in the military records. By having access to that, we will find out. We have common elements here. We have the military and armed conflict. We have also established the liability of the states in these disappearances. We have established certain doctrines of national defense and intelligence agencies working together against the state organization. They have been hiding this information for over 50 years. Also in common, we have the continuous disappearance and enforced disappearances, evidence of the lack of effectivity of these mechanisms to find them. We suffer the same. We have been denied access to this information in judicial processes and also in classified and limited information. We have sentences from the Inter-American Court for the 3 countries about specific cases of enforced disappearance that have not been obeyed, things that have to do with access to truth and also about the whereabouts of these missing people. Therefore, we want to start with 3 petitions, which are as follows. We will provide a report for its follow-up by the Inter-American Commission and the UN. We present this to the special jurisdiction for the peace in Colombia. These are records, military records, in the case of 1980, where we found a military battalion that was identified as the liable for these disappearances. Our second measure, we request that within this area of cooperation between the systems, the Inter-American and universal systems, we hope that we can compile and publish all the recommendations that throughout these decades both organizations have issued to the different countries and different states here present, and also all the countries in the region, particularly referring to access to reserve information and military records in the case of enforced disappearance. And we want to request this commission to request from the Inter-American Court advice about this subject based on the jurisprudence we have available that we have for more than 4 decades. Thank you very much. And on behalf of our missing people, we're here present hoping to find a way out of this. Good morning. We want to thank the Commission, the Inter-American Commission, and also the High Commissioner's Office, the Committee Against Enforced Disappearance, and the work group that are here and present for this hearing. It's very important for the family of these missing people. My name is Janet Bautista. I am the director of the Erika Bautista Foundation. This hearing is historic in this commission and also for the families of the missing people. We are an organization confirmed by victims of disappearances, 600 cases in 7 different regions in the country, involving state agents from the 80s, 90s, and the present time. These have occurred under the military conflict, and particularly in intelligence operations. All these cases have been impugned. There's no right to access to information, to intelligence records. So we haven't seen any action by the state attorney, by the Attorney General's office. In some cases of the special jurisdiction for the peace, that would help overcome this violation of rights. even though they have recently issued certain protective measures to protect access to these records of Brigada 20 and also the security department tasks. But it doesn't affect other groups in the country. And all the victims that haven't been recorded or accredited before that won't have the chance to have access to this information. Therefore, it's plausible but limited. The access and opening to these intelligence records was incorporated in the following recommendations of Comisión de la Verdad, Commission for the Truth. And these are obligations of the Colombian state. We are fighting now to be able to implement those recommendations by the Commission for the Truth, which is a part of the Acuerdo de Paz Gobierno FARC. So they are constitutional, and that cannot be, that they have to continue obeying these. The Commission for the Truth has said, to guarantee immediately access to information of intelligence against counterintelligence that has had the legal reserve, and to guarantee a gradual process to observe that, to have access to security records, intelligence, and counterintelligence.
These recommendations, by the failure of the current governments to take action, are currently in limbo. They have placed in limbo the search for disappeared persons over the past 35 years and more. These rights have been blockaded by the hiding of intelligence archives and files which could shed light upon the destiny and location of the victims and the circumstances in which they were disappeared. Our loved ones were disappeared. Going deeper with this, into the harm to our mental health caused by the absence of information regarding our loved ones. From a gender perspective, these cases include women and girls who have been disappeared, who have suffered torture and sexual violence, as is the case of Nidia Erika Bautista. This is an intolerable violation of human rights which continues to be hidden, not made visible, in forced disappearances. Regarding this matter, the Committee Against Forced Disappearances of the UN has spoken out in their observations to emphasize the singular cruelty with which forced disappearances affect women and children. Women who are subjected to disappearances are vulnerable to sexual violence and other forms of gender-based violence. For us, it is very important to open up these military archives. A month ago, our office received the visit of a colonel who was the commander of the 20th Brigade of Intelligence and Counterintelligence of Disappearance, and he brought us this document. We have waited 35 years to know, to have the order of the disappearance of Nidia Erika. 35 years. We brought it to the Attorney General's office, and the Attorney General's office has done nothing. So they have not valued either the document or the testimony of this gentleman. We also approached the UN, the Attorney General's office, and the Attorney General's office does not view this as important. If we had been aware of this earlier, and there must be so many other documents like this one, then perhaps we would have been able to obtain more truth and more justice, and especially a repetition. Thank you very much. Good morning, Elia Hernandez of Pro Búsqueda. As the universal and regional treaties establish, as well as the jurisprudence at the level of human rights, forced disappearance is characterized by the denial of authorities in recognizing the capture or detention and by hiding information regarding the same. It is precisely the sustaining of this silence in our countries what continues to stretch out the times of multiple negative effects of this practice. In El Salvador, for instance, at the end of last year, after the information was declassified by the Central Intelligence Agency, one family was able to have certainty about the ending of a rural professor captured in 1978 by military bodies at the time. The victim was one of more than 8,000 people who were disappeared, adults, who have been recorded by organs and organizations during the armed conflict. These, in addition to these, there are more than 1,000 cases of children who were disappeared, collected and compiled by Pro Búsqueda and the state. An official source outside of El Salvador recognized this state, given the impenetrability involved in the direct access to the registries and records of the Ministry of National Defense. Despite the fact that the law of access to public information entered into effect in 2012 and visibilized the search for answers regarding the violence in the country, and which made it possible to provide information of military and entities and relatives, it was neutralized when, under the argument of the non-existence of information or appealing to limits which are derived from matters of national security, the Ministry of National Defense has blockaded any attempt by authorities to verify in military facilities if military archives exist or not related to the forced disappearance and other crimes, as occurred with the blockading of entry to these facilities by by magistrates from the Institute of Access to Public Information in 2012 and 2020. The military personnel has avoided once and again the compliance of obligations from the sentences of the Inter-American Court, constitutional procedures of habeas corpus, resolutions of the Institution of Access to Public Information, as has been stated, judicial orders in criminal cases such as El Mozote, and requests for information from the Attorney General's Office of the nation. This negligent attitude is recurrent and has been supported by all governments elected since the peace agreements, and brings us to surmise three elements. 1. The favoring of concealment which benefits the parties responsible for forced disappearance in detriment and to the pain of the family suffering their effects. 2. Each government has ensured the support of the armed forces in exchange for, among other things, in maintaining these files hidden. And 3, maintaining a version of the history of the conflict which is partial. We have collected and systematized information regarding certain military operations and demonstrated that the highest military authorities of El Salvador have been aware of the practice of forced disappearance of children. Based on this, Pro Búsqueda has also managed to resolve more than 463 cases of disappeared children in the world, and with official information, it would be possible to solve many more cases. To summarize, the aforementioned shows that the situation has not varied at all since the year 2019, the date of the last visit in situ conducted by this commission to El Salvador. For this reason, we request that this Honorable Commission reiterate its recommendations to systematize and make available information within the state related to these violent acts, and 2, the compliance of the state of El Salvador with their internal regulations and universal and regional treaties. Thank you. And thank you very much. I am the son of 2 detainees and people who were detained by the policy of the state of Guatemala of forced disappearance. Throughout the continent, we have lived continuous violence as the result of a series of authoritarian governments and military dictatorships which have used the systematic practice of forced disappearance as an element, a repressive element of their national security policies, and implemented by the security forces and the dictatorships of these countries, which most of the countries in our continent have suffered. In Guatemala, the first cases which show evidence of the systematic practice of forced disappearance was in 1930 in the dictatorship of Jorge Urico. Then the counter-revolutionary governments subsequently practiced these forced disappearance as a practiced to justify and addressed to victimize those promoting the agricultural agrarian reform of the government at the time. Nonetheless, in the case of 28 leaders of the Labor Party in Guatemala who were captured, tortured, and murdered and disappeared in 1965 and 66, this is what marks the beginning of a state policy of forced disappearance, which was implemented by these state security forces and operated by the clandestine system of the Guatemalan state, according to the doctrine of national security and military documents which were in effect at the time. According to the Commission of Historic Clarification, various victims have been identified. A procedure of the Congress of the Republic of Guatemala of July 28th declares the national urgency of searching for and locating the Guatemalans who are currently being detained illegally and have been disappeared, and calls on state organs to press for the necessary legal and humanitarian measures to address this issue. The relatives of the victims, we have the right to truth, to justice, and to reparations and to non-repetition.
According to the international standards issued by the organizations of the UN and Inter-American Commissions, most of the cases involving disappeared individuals are still impugned and unresolved, product of this just system in Guatemala. In this systematic abuse, when there's the right type of practice, we are all victims, of those who are defending this and those who have been victimized. DNA of skulls, of bodies, of disappeared bodies that we've been able to find and recover thanks to the investigation of the social society and the victims. It's just slightly over 4% of all disappeared individuals. They have been found in clandestine tombs. They have been found in military organizations and institutions. We still don't know where the whereabouts of the bodies of all the disappeared individuals, despite several sentences, including the Judicial Álvarez and Yuto Hill cases, Blay, Chita y Nek, and others. Parecían familiares Babaca Velázquez, Panel Blanca, members of the Dia Chuchupaqui, Comunidad Latina del Municipio Radical, Bolivia Taser, Massacre Aldea Josefinos. In none of these cases has the state had an effective search or strategy to search the victims, to find them. And quite the opposite. There has been nothing but impunity. So there's absolutely no willingness by the state to obey and to comply by the sentences issued by the Inter-American Court. Something very clear to us is that in Guatemala, the work of organizations for the victims has shown that the military areas, military bases, were used as clandestine centers for illegal operations, used for the retention, torture, and hiding of bodies of people who were determined to be internal enemies according to the national policies, the military manuals of that time. That's how in several occasions we have been able to obtain information about the possibility of finding the whereabouts of one missing person within a military institution. We have found 565 skeletons. For example, the 21 military zone in Cobal, where there's the regional training center based on the UN doctrine. We have found these missing individuals there in private properties. Those were used also for the operation centers for the military in clandestine areas to hide bodies. Despite all this, and besides all this, one of the systems to avoid the reparations, they established barriers to be able to obtain this. We, the victims, have witnessed the attempt to hide police records. There's a specific document that has over 80,000 documents that are clearly important to establish the whereabouts of the victims. These documents have helped us to find a lot of people who were missing, who were hidden by the military without any identification. In the case of military records, we have obtained these by the search for justice by the victims. They have been establishing pressure to publicize these records. Despite the fact that the authorities denied its existence, there are documents that show otherwise. We have found plans, manuals, reports, among other reports and among other documents, through court orders. These are historic documents. After the military and the violence stopped and we went back to democracy, we were able to achieve this. These actions allowed us to counteract the version of the military. And now we have these documents that actually support what we have said. During the detention of these individuals, we have found complete records which contain all sorts of documents, including identification information of missing people. We found copies and originals from the security organizations of the state. These were war trophies and nothing else. We demanded this for 40 years. The state needed to give this information. We wanted to know the whereabouts of the missing people. We have been able to achieve some of these. And we know there are military and police records. So this allows us to find our missing families. So we request from this commission the specificity of these military documents and to make it available to the population. We know they exist. We have seen them. For example, in Guatemala, it's an important case. People facing the judicial systems, they use the state policy of disappearing people. They have copies or, in fact, originals of the military documents with information about those people in their own homes. We ask that this CIDH ask the state to provide to us, to the prosecution offices, to the Human Rights Prosecution Office, all the military records during the conflict that Colombians, Guatemalans, and Salvadorians suffer. And we want to have the rights to the truth.
Second.
Very good morning. A special greetings to the authorities of the Inter-American Commission of Human Rights and representatives of civil society and all others who are present and who follow us virtually. I am Guillermo Fernandez Maldonado Castro. I participate as representative in Mexico of the High Commissioner's Office and of the UN for Human Rights at the invitation of the Commission and the organizations of civil society to this hearing. I am here to offer information orally, not under oath, and I will transmit a joint message from the Office of the High Commissioner of Union for Human Rights in Latin America, the Committee Against Forced Disappearance, and the Working Group Against Involuntary Forced Disappearances. This is due to the limited time that I have available and to the prejudice of each entity. None of my comments can be understood to be an express withdrawal of the express privileges of the UN pursuant to the conventions thereof. My first words are in homage to the individuals who have been disappeared and to their relatives and loved ones and the persons who search every day for information to clarify these cases. For decades, they have defended the rights to the search for truth, justice, memory, and the non-repetition. Thanks to their valiant activities, they have consolidated reforms to eradicate and prevent this crime which affects victims and all of humanity. Without access to information, it is impossible to access truth and justice. Despite of progress that has been made, there are still profound challenges to finding information regarding disappeared individuals for institutions in charge of search and investigation. For example, in Colombia, regarding disappeared persons in the context of the armed conflict, this includes forced disappearance and other forms of disappearances Given the magnitude and severity, the peace agreements have been an opportunity to clarify these cases. We emphasize the commitment of the government, which has accepted the jurisdiction of the committee to receive individual communiques, and also the bill for strengthening the search for disappeared persons. Likewise, it is important to adopt effective mechanisms and expedited mechanisms of follow-up for laws to access information regarding the violations of human rights in Mexico, where there are more than 110,000 people officially recognized as disappeared. The regulation stands out, which prevents accessing this information, and the precedents from the Supreme Court and the organs of transparency, but we must take other steps, especially regarding justice, public safety, and other organs. There is the lack of registries and data according to the provided for by law. Reports have been made of more than 5,000 migrants who have been disappeared in Central America and Mexico between 2014 and 22. These challenges were identified by the Committee of the United Nations Against Forced Disappearances in their visit to Mexico. The application of these recommendations is of key importance, such as the application of mechanisms of regional information for the search and investigation of disappearances and follow-up with victims. To this end, it is of priority for states to have effective and efficient mechanisms to fight this, such as the mechanism of support abroad, ensuring that the authorities in charge of searching and investigating disappearances, as well as relatives and loved ones, will have full, timely access to all of the information in order to locate disappeared individuals, sanction the responsible parties, and give reparations to the victims. This access includes information regarding public authorities, state actions, and intelligence, and administrative information used in the search when information can involve a risk to national security. Measures of confidentiality must be established, but this cannot impede access to institutions in charge of search and investigation for families and others with legitimate interests. For this reason, states must adopt measures to preserve archives to be consulted, and to identify and declassify information of public interest. Any individuals with legitimate interest must be able to access information regarding the progress in the search of disappeared individuals and the investigation of their disappearance, including criminal proceedings, protecting and guaranteeing all the phases of research, search, and investigation. This must include authorities informing victims and loved ones and relatives of the actions that have been taken, challenges faced, and the results obtained. These principles are applied to cases of the present and past. For this reason, access must be given to all information to clarify past cases. For instance, in Argentina, and Chile, Paraguay, Uruguay, Honduras, and El Salvador, access to information is key to access truth, justice, reparations, and the guarantee of non-repetition. Furthermore, access to information is key and crucial for to satisfy the rights of victims, to strengthen democracy and consolidate a stable and lasting peace. It is inevitable for victims and society to be able to trust authorities in charge of search, investigation, sanction, and reparation for these severe violations. The office that I represent, the Committee Against Forced Disappearance, and the working group, we will continue to exhort and accompany states in strengthening full and effective access to information in favor of state strategies to prevent and eradicate forced disappearances and the impunity related thereto. We will accompany victims in demanding their rights and state authorities in order to fulfill their responsibilities and obligations in pursuant to national and international obligations and human rights norms.
For keeping within time, in fact, using less time. That is so good. Thank you. I now invite my colleagues to intervene, and I call on the country rapporteur first. No, I'm sorry, the country rapporteur to make her intervention.
Okay, thank you very much.
Well, your country rapporteur or
No, thematic.
thematic, yes, thematic rapporteur.
Sí.
Yeah.
Muchas gracias.
Thank you very much. I'm the thematic rapporteur. I would like to begin with cordial greetings, firstly, to the representatives of civil society, also to our dear friend, Fernández Maldonado, who is always with us from the Office of the High Commissioner. Speaking about forced disappearance, and I don't have to tell you what it means, it involves discussing a complex violation of human rights, not only to life and integrity. For this reason, the Inter-American Court in this historic case of Velázquez Rodriguez establishes that the search for individuals who have been disappeared is an obligation of the state, which cannot be put upon the relatives solely. In the case of disappearance, if we include the cases of women, which Janet, which I would like to give special greetings, presented, we are talking about the requirement to reinforce, and along that guideline, I'd like to make a few more comments more than questions. And if Janet and her workers search for her sister, husband, everything that forced disappearance involves for victims, but also for relatives, and among those relatives, what it means to be searching, what it means for women to be searching. This has not been visible. This has been made invisible when we talk about forced disappearance of women. We talk about disappeared women, but the Inter-American Commission, we are working on this in the context of international women's rights. We talk about women who are searching, who have to learn. There's no university that teaches you how to search for someone. They learn day by day. Women who are searching in Colombia and Mexico, they call them the crazy women with the shovels, because they go out with shovels to dig in the earth. It's very important in the analysis of forced disappearances to work with this gender focus. We are here speaking about complex violation, and in the case of women, how sexual violence is immersed and it is made invisible. The Truth Commission of Guatemala, and then Peru, and then the court, in certain cases, when they said, when you find the body of a disappeared woman with indications of sexual violence, this is made entirely invisible. And in that line of thinking, we are talking about the access to information and archives, how to find information regarding women which were certainly not included in the archives. So I would identify two stages. One, finding the archives and opening them. And second, how to recover this information that was never recorded in the archives. If we're talking about access to information and the work of archives, which I believe is very important, from that point we need to think about methodologies in order to find and search for information in those archives which they're not talking about women, and that's something that we need to begin working on with methodologies, particular methodologies. In the case of Colombia, for instance, with this very well-known report, they began working, and then the Center of Historic Memory trying to look for, maybe in one line, one testimony, what had not been stated overtly. In this sense, from the Commission, more than any questions, I would like them to still be hearing these stories. What did it mean to be searching as women, and commit ourselves to supporting, and the committee here, the team is here, supporting with guidelines for the declassification of archives with a gender focus. Because it is fundamental. If we don't begin to put this topic into the search, it will not be found. So please, I would ask you to please tell us more in the case of women. Janet, my recognition, my respect for the struggle that you have made for your sister, for your husband, from exile, returning to Colombia, continuing to search. That's something that the Commission respects and values. Thank you, Chairperson.
Country rapporteur. No, you're not speaking as no.
I want to defer to
No.
I will defer to Commissioner
No, you can't do that.
Yes, I can. I can.
No, you can't. I am in control.
All right. Well, I haven't put up my.
No, you don't have to put sorry. No, you can't. You have to follow.
Thank you very much, Commissioner Macaulay, and thank you very much, Commissioner Rallon, for allowing me to speak now. I want to start off by, first of all, saying the information on the magnitude of forced disappearances is quite dramatic. And sometimes we lose the humanity of the situation in the numbers. And I want to appreciate the display here because of the faces of the persons, some of the persons, a fraction of the persons have disappeared. And I also want to recognize the testimonies of those of you who have also lost family members in this. And thank you for your commitment and determination to get to justice. I think it is very clear that information is the precondition for justice, for reparations, for obligations of non-repetition, and for state accountability. And to the extent that you can't access information because, of course, there are conspiracies of secrecy that protect those who have committed these atrocities, I think we have a collective commitment to address that. So I just wanted to start off by saying that. I have had a chance to look at some of the standards of the Inter-American system, and like my sister, Commissioner Mantilla, understand that within the Inter-American human rights system, there are very clear standards on the right to information in the context of forced disappearances. And she's already alluded to some cases, but it seems to me, I just want to reiterate that the court has pointed out that the state should never deny access to information to members of the judiciary that can verify legitimate, unless they can verify the legitimate objective of confidentiality. And I start that way because what I want to ask you, to what extent have you used the court system to get over this hurdle of inaccessibility of military and security records, and what has been the result of those efforts, having regard to the clarity of the conventional control around this question? I have another question, but I want to defer to Commissioner Alon, and if I get a chance again, I will come back. Thank you very much.
Gracias, Presidente.
Thank you, Madam Chairperson. First and foremost, I have a few words to acknowledge the efforts of all the people searching for the loved ones. And you, here in this regional hearing, are the voice of many, many other people. This is a courageous action. And of course, there's a specific attitude in the face of pain. This is a heroic action. We have been able to straighten some injustices. I have two comments, two specific comments, because throughout this hearing all these comments, there is no question that we face a lot of challenges. Some of them have to do with research and investigation. There's no doubt that in the different prosecutorial offices, there's a lot, in many occasions, there's this challenge to have enough people, enough personnel, to have the appropriate focus on the human rights, but also to allow them to provide any information, as minimum as it seems, to be given the necessary importance, and so that the states can actually move forward in their investigation to find the truth, to find the justice. The other point has to do with the access to information. The access to information, as it's been mentioned before, has to include the totality of the information. There's no exception. There, except for specific issues of public safety, security. But absent that, this access to information has to be wide and fast. It has to allow people to move forward, to advance in their research. The access to truth is twofold. On one side, it's necessary to be able to advance the investigations to find the victims. But on the other hand, as you provide absolute access to information, there's also this willingness and transparency by the authorities, which helps these processes not to be stagnant for decades. So they keep moving forward, advancing, and that also creates or causes some reparation from the social standpoint, the type of reparation that using the appropriate justice, you can have a society or societies where everybody finds the necessary and collective reparations. So I want to thank you all for the information you have provided us with today. This being a regional hearing, I believe these two points about the challenges of investigation and maximum access to information are the most crucial. Thank you.
I now invite the Executive Secretary to make interventions.
Gracias, señora presidenta.
Thank you, Madam Chairperson. Good morning, everybody. I'm very happy to have this hearing here on this second of the regular sessions. One day before March 8th, I think it's very important to highlight the actions of women during the search for their loved ones in Guatemala, El Salvador, Mexico, Honduras, Argentina, Paraguay, Uruguay. Women who are seeking justice and searching for justice, and that due to some personal issues have made of this search a political issue. I believe that's the most important thing when we talk about justice, gender-based justice, how it affects women, you know, the need to understand what happened. This makes us put together the UN system, represented by Guillermo Maldonado, and the Inter-American system. We're all here together, not only to demand the participant states' responsibility and the due diligence in the investigation, but also to preserve history, to have a constant and solid voice in the search for justice. To come here to the Inter-American system and make this public is such an achievement for many of these organizations, but it's also an achievement for the human rights systems to be able to have this priority in this subject in our agenda. It has to be a visible subject. There's going to be another hearing on disappeared individuals here, and tomorrow there's going to be a press release about the value of women looking for their loved ones. Janet Bautista, I'd like to address you, ask you a question about this law in Colombia about women who search. And I would like to hear you tell us what's the value of this initiative. This is a regional hearing that's being broadcasted live throughout the continent. And we would like to know what is the added value that you see in this type of initiative. We want to know if this is an example that can be repeated within other contexts in the region. Thank you to all the members from El Salvador and Guatemala por Búsqueda for your tireless work, over 30 years working on this, and thank you for coming here and giving us this personal story. This friend of ours from Guatemala, thank you.
The third freedom of expression, you have 2 minutes.
Muchas gracias, Presidente.
Thank you very much, Madam Chairperson. This is very important for the Commission. Around 2020, a report was published about the right to information in Security National. That's linked to this. The Commission appointed me to represent the Flores Vergal case, which had a hearing in February of 2022. And this year, in January of 2020, actually reinforced some standards, which I want to share with you. The court indicated that the access to information in military records is indispensable, is crucial to establish the state responsibility and find the truth. in that effect, the court said that authorities have to make, and I stress they have to make this available. This is a case of enforced disappearance that actually points out the participants in this hearing. The court also said that the state has to respond. They cannot just argue that the inexistence of information or the acts. They need to rebuild, reconstruct, and put together information that will take us to have access to the truth. They also talk about the administration of justice and the relation of information with memory and information with the truth. But I want to mention something that the Commission defended before the court. We're talking about the point of view of families and victims. And there was a document in this hearing that was shown about an individual disappearance. And in the Commission, the Inter-American Commission, the families have special interest about access to information because that search has to be understood as part of the construction, reconstruction, the building of individual information. They investigate and publish intimate and daily pieces of information. This could be crucial to find those people who were taken from us. I have a question. Do you think that these institutions in your corresponding countries, there's an availability to move forward in policies to establish access to information in the case of disappearances? Thank you very much.
Thank you very much. We have run out of time for the Commission, so I will hold my comments until the close of the matters. I feel very strongly about this as one of the most painful violations that can occur to anyone, any of our loved ones, and it's unimaginable, the continuity of the pain. Anyway, I now invite you to make your final comments. 22 minutes, I believe. Let me just double check. Yes. No, 20 minutes. Sorry. You lose 2 minutes.
Well, thank you very much. On behalf of the Foundation and our colleagues and sisters and brothers in the struggle, thank you for your words, for your recognition of our work. For us, it is important. And we have the petition with the Inter-American Human Rights Commission that they continue with this work on forced disappearances, and the High Commissioner's Office as well doing their great work on forced disappearances. We request that you continue your efforts, hopefully with statements and in other ways with monitoring, oversight, follow-up, and hopefully it will be possible to have a follow-up hearing on this hearing to go further in depth and for states to have representation and the presence as well, direct presence of the organs of the UN who could not be present today, for them to hear the voices of victims and especially to pave a way to resolving these situations. For us, it is important for the Commission to address the states of Colombia, Guatemala, and El Salvador to accelerate the procedures of declassifying and opening archives of intelligence archives related to forced disappearances so that they will contribute to shedding light on the location and also on the parties responsible for these cases. We are concerned as well with the lack of protection for women who are searching, people who are searching, who are working as well to have these intelligence archives declassified, which can be a risk factor, increasing their vulnerability. We find this very important. And we believe that the declassification of these archives should be a part of public policy of search of the states. These archives should be the patrimony of humanity. Now, to answer the question, perhaps we can go expand more later about the law for women searching. I have brought a copy here. We have sat down with 8 organizations of women of African descent, indigenous women, rural women throughout the country. In hearing their cries, we have seen how the civil and political rights to life, to integrity, to sexual and physical safety and integrity, the right to not be kidnapped, the right to not suffer extortion, the right to not receive threats or consequences have not been considered crimes by the Attorney General's Office of the Nation. Practically, they're assumed as collateral damage. So for more than 35 years that these disappearances have occurred in Colombia, they have not investigated one single crime of violence against women who are searching for missing people. This, in addition to the reality that the load has been placed on the shoulders of victims and families for searching, and this has affected their economic, social, and cultural rights. We, women, turn old without Social Security, without retirement pension, without work, and we have done the work of the state, and the state has not recognized us. Quite the contrary, they have persecuted us. So the threats, the retributions that we have received here is my daughter. She is the legal coordinator of the foundation. She has faced several dangers and threats for helping victims and relatives. Is that all my time? So this law still has a lot of risks in our National Congress. It has been boycotted by congresspersons from the right-wing congresspersons who have prolonged throughout several months the designation of the components and of those who must present a report for it to be brought into debate in the commission, firstly, of the House of Representatives. And now they are opposing it with an argument which has no legal support, which they say that it should have the concept of various ministries of residence, labor, justice, and the unit of victims. And because they have not received those items, they say that they cannot process it. So we fear that on June 19th, this legislature will close, they will archive, file away this law because there's not political will to process it. That's terrible for us, because we have fought for so long to develop it, create it with popular knowledge of women and with our intellectual power, and this is the hope that we don't want to lose. Thank you very much. Thank you very much. We would like to, regarding the question that the commissioner has made, we would like to say that there is will in this at this moment in Colombia. For instance, we cannot stay at this point as officials in the government. We want to go further in and deeper. In the case of Colombia, we have the law 1712 and 1721 regarding access to reserved information. In fact, one of them clearly states and proposes that in the case of severe violations of human rights, there is no reserve. We have the sentence from the Constitutional Court of 2018, which reviewed another decree regarding search, which just states that there is no reserve, but in the practice, for 5 years, the search unit could not access information. We have not been able to access the majority of cases in the ordinary justice system, so what is required is that we regulate these laws through ministries, the Ministry of Defense and others, to order clearly how to apply these laws in different contexts, and we need the will of the military forces. Secondly, we believe that access to reserve information cannot only be through transitional justice or extrajudicial actions. We have the right to justice as well in the context of ordinary justice systems. And in Colombia, we have this latent risk with the argument of confidentiality, the judicial system and humanitarian issues. This cannot deny the fact that information that is reserved can also be accessed by relatives and by society at large. Thirdly, we believe that the follow-up on this hearing will be very determining factor, not only for the 3 countries that are present here, but for the entire continent. We believe that access to reserved information will help us see to it that these figures of thousands of disappeared individuals can be decreased by finding them, finding not only their bodies, but especially finding out what happened, the truth, and bringing about justice. We trust in all of you. For that reason, we repeat again, finally, that a consultative opinion from the Inter-American Court would help us to at least clarify this road to take. We insist on this. We believe that it is a viable option. Regarding habeas corpus, this opinion would help us open many paths.
Bueno,
In the case of El Salvador, about whether we can find or see any advance in policies and resources to have access to public information. We believe that the law of access to information, one of the best laws created or enacted after 2012, this is a very important base for the history of transparency in El Salvador. Now, as we said before, it ended up becoming useless because of all the blockage and the stops to all the institutions who were seeking this information. The Defense Ministry established limits. The executive power also blocked access to this information of military sources. Now, if this was limiting, as it was, the action by the executive and all its institutions has affected this even more. The current situation is even darker, I believe, because of the institutional weakening that has been created in this current administration. We believe that it is possible to direct these investigations to other sources. However, there's a specific point that's always hanging and going nowhere, which is this information that we haven't been able to gain access to. ProBúsqueda, this organization, has undertaken a lot of investigations about military operations, following certain standards set by the Inter-American Court. One of them, this case, about a military operation in 1981, where a child disappears, is forcibly disappeared. There's a sentence now by the Inter-American Court regarding this case, and we have found here the use of chemical weapons, and we were able to see this from the Central Intelligence Agency communications. We also, from their information, we found out about the constant attacks to the civilians in this operation, and there are specific details that have been provided to the Attorney General's office. These are some investigation points that we can also submit to this commission. And we want to reiterate our concern, because this situation has more uncertainty as the time goes by. It doesn't help us to satisfy the need to find it and bring the truth to the families and loved ones of disappeared individuals. Thank you. Thank you very much. In the case of Guatemala, I would like to bring up the names of Aurena Farfán, Blanca Hernandez, Marcia Mendez, who were the mothers, the sisters, the wives, who taught us, the next generation, how to search for our loved ones. I'm here because Aurena Farfán held me by the hand and said, "This is how you search, my son." We have learned from them. We have a method to this because they developed them in the past without being researchers or investigators, to be able to document the violation to human rights. It's thanks to 30 years of work from these people, the associations, victims, family of victims in Guatemala, that we know that the military centers were actually used as a extermination and torturing center. Nowadays in Guatemala, we have a very complicated situation where we see how they promote laws in the Congress to promote impunity and try to make people forget this. They release military personnel who have been accused of crimes against humanity. The attacks against women who are still searching are still there. In Guatemala, the situation around the access to information is very weak. If we have any information from military documents, it's because of the struggle and constant action of these women, not because the state granted us that. The state refused to give us information, and they denied that there were any military documents. Well, we have evidence that, and we have it with us, evidence that that information exists. We have requested information from the prosecutorial offices to the Ministry of Defense, and they keep answering that that doesn't exist. There's no such thing. We have found them in the houses of people who were put in custody for serious violations of human rights. We consider that we need to make public all these documents. They have said that this is an issue of national security. However, there's internal jurisdiction where documents have been lost. Documents that are historic documents that have nothing to do with national security. We cannot keep thinking that the internal enemy is us, the ones who are looking for their missing people. That's their national security. They're afraid that we, the victims, look for our people, and that's why they withhold the information. We keep thinking that we're at war when we are at peace and we are the democratic state at this point. This is alarming because these investigations that have been taken on, we have been able to have an impartial prosecutorial office. They have been attacked by the state, by the system, for that impartiality. So as Guatemalans, we request from this commission to have follow-up hearings, thematic hearings like this one and private hearings, to follow up on this request. And also, the representatives of the different countries should participate in these meetings, in these hearings, so that we can do the follow-up and we can overcome all those challenges, the challenge faced by the access to information. With your support and observance, we will be able to advance and move on. And hopefully we can have access to justice, to truth, to reparations, and the guarantee of no repetition. Thank you very much.
I will now make a very short closing statement, comments, which I have myself. As some of you know, I was a judge of the court. And this is one area that no one can say that the court has not been extremely clear about the responsibilities and obligations of the state's duties to investigate, and investigate properly, and investigate and find the truth, find the remains of the loved ones who have disappeared, find those who were assassinated in massacres by the armies of the state, find those who were killed and massacred by the police within the state, and give the remains to their loved ones so that they can be properly interred. And as you know, it's clear. The court stated clearly in so many cases when I was there, and certainly continues to do so. And yet states still act in impunity in protecting the military reputation, story, what have you. And certainly there can be no reason to use the security card when somebody has been disappeared for 30 years or 40 years. That's impossible. And techniques and knowledge and machinery and so on have improved in finding the remains of people. So they have no excuse. On top of that, when it's a military operation or a police operation, they have records. They can even pinpoint which bullet did what. So they cannot hide and say they have no records. They can't find the records. These are institutions of record keeping. So therefore, we will do what we can to strengthen the fight that you have in finding the truth and in obtaining justice, and so that you can keep the memory alive of your loved ones. In addition to that, please remember that we have a rapporteurship of memory, truth, and justice, and which you could work closely with. And I'm requesting Senora Batista, if you can let us have a copy of that research report with what women have done. I love the fact that you named victims. It is a very powerful tool. We had a hearing of Afro-descendant United States mothers, and they not only provided photographs, but they named their loved ones, their children, their parents, their brothers, their sisters, their husbands, their partners who had been killed. And I think it is a powerful tool, because not only does it affect those who are sympathetic to you, but it also penetrates those who have only the state's interest at heart, because you're forcing them to face up to not only the face, but also the identity of the disappeared and deceased. And I think they're entitled to all that dignity of being known, being named, being remembered, because their dignity as human beings was taken away from them and continue to be taken away from their loved ones. And remember that the court too, and the commission, has been very clear about reparations in these circumstances, which ought to be proffered by the state. One shouldn't fight for it. And it is not, we're not only talking about material reparations, we're talking about the granting of the dignity, respect for the dignity of the deceased and disappeared and deceased. And we're like a public apology from the highest official of the state, putting up of memorials and so on, so that they are not forgotten. These are not insects. These were human beings entitled to all the rights of every human person. So we hope we can assist you, and we hope we can work with you some more. I thank all of you for coming. I thank all those who are here to listen, and I thank my colleagues who intervened, and special thanks to the interpreters who made us understand, those of us who had to listen to a language we did not fully comprehend. Thank you. I do it again.
Record.
AG1 is so much more.
con el host Leonardo.
Dale, dale.
English 1-2, English 1-2.
Finalmente procedemos a probar interpretación y captions. Probando canal 10. Probando canal 10. Espero confirmación. Probando canal español. Intérpretes, por favor, si pueden confirmarnos.
button here.
And just press this to speak. You're done. Okay, so you just scroll up and down like this to read. Okay? And you can share it.
Recording in progress.
Muy buenos días a todos y todas. Doy por inaugurada la audiencia número 4.
Welcome to hearing number 4 of our period 186 of sessions. The Inter-American Human Rights Commission. This is titled The Human Rights of Indigenous Peoples, the Taíno and Cimarrón Peoples in Jamaica. This was requested by the organizations. And my name is Esmeralda Arosemena de Troitiño, the first Vice President of the Inter-American Commission and Rapporteur for the Rights of Indigenous Peoples. I am joined today by the Commissioner, Second Vice President, Roberta Clark, Rapporteur for Jamaica, the Commissioner Joel Hernandez, and Commissioner Carlos Bernal. Thank you very much. In addition, in this hearing, we have the presence of Executive Adjunct Secretary Maria Claudia Pulido, Rapporteur for the Freedom of Expression, Pedro Aca, the Special Rapporteur for Economic, Social, Cultural, and Environmental Rights, Soledad Garcia Munoz, the Coordinator, if the Coordinator is present, for Precautionary Measures, our Executive Secretary, Tania Renaud. I would like to begin with greetings of solidarity and my recognition of the petitioners and organizations which have requested this hearing. Thank you for being here, present today, sharing on such an important topic for our knowledge and information. The illustrious state of Jamaica, which is not physically present, it is my understanding that they will be connecting online, virtually. Given this situation of the lack of physical presence of the state, we will allow civil society to have the time, a bit more time than what we had scheduled. Given the absence of the state, 18 minutes, perhaps 10 more minutes. And then the commission will participate to have the opportunity to exchange information with the petitioners. Subsequently, we will give them the floor again for final comments from civil society and the commission. So, we will immediately begin with this hearing, which, as has been stated, is related to the topic of the human rights of the Taino and Maroon indigenous peoples of Jamaica. Civil society now has our recognition, and we give you the floor.
Si quieren,
If you wish, you can identify yourselves so that we will have the proper recordings of your participation.
Usa kasi ni bonrish kai mandiri. Kasike yukayaki yame wanidaka. Greetings, I am Chief Kalan Nibonrish Kaiman of the Jamaican Hummingbird Taino people.
Greetings, I'm Gama Gloria, Mama G. Sims, Paramount Queen of the Maroons of Jamaica.
Buiti Binafi. Good morning, good day. I am Cynthia Ellis Lubafu Isieni, Ambassador at Large for the Garifuna Nation, supporting our relatives from Jamaica and around the world.
Biti Benafi. My name is Michael Sabal. I'm the acting president of the Garifuna Nation, and we are here in support of the Maroons in Jamaica.
Kualitonali no chantlake no chansiwan de womasatsin iwano yolopaki ikwak nimisita. Buenos días, buenas.
Good morning, good afternoon. I am the first coordinator of the International Council of First Nations. We are here supporting the peoples of Jamaica. Tlasukamati, thank you.
Me, Elaine of Freedom Imaginaries.
Tehuvet damet, tovangar honuk vetam, ahihirom. Ehu inkem. Kalani bonrish kaimandiri, kasike yame wanidaka. Good day to the land of the Tongva people, ancestors, elders, relatives. I am Kalani bonrish Kaiman, Robert Pierman, kasike of Yame Wani Taino people. And we start by acknowledging the Gabrielino Tongva, the traditional caretakers of this land, the Fernandino Tataviam, the Chumash and the Ajachamen, and all our relatives to the east, south, west, and north of where we are gathered. We thank this land for accepting our people and call on their support for activities today. Kokoli. And now Gama Mama G with libations.
Greetings. We give thanks for this day. Give thanks for this gathering, this circle. Give thanks for life. Give thanks for journey mercy that enabled us to be here. This morning we ask, as we come into this room, that justice will be done. We ask that all injustice will be nullified unto our people, and that this gathering will bring cooperation, collaboration, and further healing. Ashe, give thanks.
Good morning, Commissioners. My name is Melanie Alain of Freedom Imaginaries, and I'm honored to present the delegation of Indigenous leaders who will address you on the human rights of Indigenous, Taino, and Maroon peoples in Jamaica. In person, I'm delighted to be here with Cacique Kalan, Taino chief of the Jamaican Hummingbird tribe, and Gloria Mama G. Sims, Paramount Queen of the Maroons, as well as our supporters from the Garavuna Nation. And from Jamaica, Commissioners, we have pre-recorded greetings from the colonels of Jamaica's Maroon communities, and so I invite you to listen to their greetings on video.
Mabrika, Kaikotakina Diri, Kasika Eani Yamewani. What I've just said in my own Taino language is, greetings, my name is Kaikotakina. Kaikotakina means island food teacher. I am the chieftainess of Yamewani. That is Jamaica Hummingbird Taino people.
My name is Marcia Douglas, currently the Chief or Colonel of the Charleston Maroon community.
Good day, everyone. My name is Wally Sterling, and I'm the Chief of the Moortown Maroons. And this Moortown encompasses more than just one community. It's most of the community in the upper part of the Rio Grande Valley, in the parish of Portland in Jamaica.
Yes, I am Lloyd Latimer, the Chief of the Scotsall Maroon. Scotsall is located in southeastern St. Mary, and a population of about, I would say, 3,000 people, because the community has narrowed down. But the space, the wider space that Scotsall takes up, it's about 6,000 to 7,000 people.
And Commissioners, I now turn to Cacique Kalan, who will briefly discuss the history of the Indigenous Taino and Maroon peoples. And after that introduction, we will highlight priority issues affecting the rights of Indigenous Taino and Maroon people in Jamaica, including from an intersectional perspective that highlights the experiences of Indigenous women.
Jamaica was originally inhabited by the Tainos, historically but inaccurately also called Arawaks. In 1494, Jamaica was claimed by Spain, who in short order put the peaceful Tainos to do free labor for the emerging gold industry. Though the Spanish invaders caused the death of the majority of the Tainos in Jamaica in the early 1500s, we did not all perish. The first Maroons in Jamaica were therefore the Tainos, who escaped the arriving Spanish and their encomienda system into the mountainous interior of Jamaica. Colonial narratives falsely assert indigenous extinction by as early as 1520. However, archaeological evidence suggests small Taino populations existed during this period. Census records also report Indian populations alongside enslaved Africans in Sevilla la Nueva in Jamaica in 1533. During the colonial onslaught, the indigenous people existed in the mountains, on the coast, remote fishing villages, and in plain sight. Indigenous people of Jamaica have never been extinct. In 1655, England wrested away Jamaica from Spain, adding it to its Caribbean colonies, and in the process waged war for over 85 years against the Maroons. So as to sustain its colonial sugar-based industries, England sought to replenish the severely diminished labor force by importing Africans into Jamaica to work the plantations and keep the wheels of colonial enterprise turning. Continuous resistance and escape by the increasing number of enslaved Africans led to the expansion of Maroon settlements in the mountainous interior, many of the early Africans having run away to the interior to join Amerindian communities or Yame Taino communities. Jamaica's Maroons of today are therefore descendants of Jamaica's first peoples, as well as descendants of self-liberated enslaved people indigenous to Africa, who have retained African identities through spirituality, ties to the land, social and political organization, medicinal healing practices, dress, music, dance, and language. Gama Mama G.
In Jamaica, 2 treaties were signed historically between the British colonial government and the Maroons. One in 1738 with the Leeward Maroons in the western interior of Jamaica in and around the Cockpit country, and the other in 1739 with the Windward Maroons in the eastern interior of Jamaica and in and around the Blue and John Crow Mountains. The Maroons Treaty recognized Maroon liberty, freedom, self-governance, and ownership of land. Today, Yankunkung Pikibu Maroons continue to claim our rights to self-determination and to govern and occupy our treaty lands. The Yankunkung Pikibu Maroon also maintain a unique system of communal held treaty lands as part of our ancestral heritage and collective identity. Although related, the Taino and Maroon communities of Jamaica are distinct communities. Applying the International Labour Organization ILO Convention number 169 on indigenous and tribal peoples in independent countries, the Taino clearly qualify as indigenous. The Maroon can also be considered as indigenous to Jamaica on account of being descendant from the original Taino and our retention of our own social, economic, cultural, and political institution. Maroons in Jamaica, however, can also be considered as tribal peoples, based on the fact that our status is regulated partially by our own customs and tradition and by special laws or regulations.
However, despite the Tainos being featured on the coat of arms of Jamaica and the Maroon national heroine featured on the national $500 note, the Tainos and Maroons of Jamaica have suffered from the racist laws, policies, and legacies of colonial and post-colonial governments of Jamaica and its land, social, cultural, and religious biases and discriminatory practices. The government of Jamaica, from colonial times to the present, has blindly accepted and wrongfully perpetuated the myth of indigenous extinction in Jamaica. It has never acknowledged that Tainos continue to exist or that Maroons are entitled to the rights of indigenous and tribal peoples. In its recent review of Jamaica, the United Nations Committee on the Elimination of Racial Discrimination expressed concern about the government of Jamaica's refusal to recognize Maroons and Tainos as indigenous peoples. Please note that the government of Jamaica had referred to us as indigenous culture. Jamaica's constitution and laws do not recognize, guarantee, or protect the rights of indigenous peoples under the United Nations Declaration on the Rights of Indigenous Peoples and the American Declaration on the Rights of Indigenous Peoples, such as our right to self-identify as indigenous and our rights to self-determination, autonomy, ownership, and control of our ancestral lands and resources. There's no mention of Taino in early childhood education system in Jamaica. This is a part of what can be called paper genocide, perpetuating the myth of Taino extinction. In this structural context, the indigenous people in Jamaica are exposed to serious threats to our way of life, as we will now discuss.
So as Kasika Kalan said, a major structural issue is that Jamaica's domestic legal framework does not recognize the communal land rights of the Maroons. And there is an urgent need to demarcate legally recognize and protect the boundaries of Maroon lands. And we have a video from Colonel Sterling and Lati Bodair from Jamaica to talk about this structural issue and how it manifests in their communities.
One of the major problems that we have facing our community at this point in time is the matter of land tenure. All four parents had an agreement with the colonial government that they signed in 1739, on the 23rd of June, and it gave up our forefathers a total autonomy over the communities that they preside. And there was nothing in that agreement that says that our forefathers should have paid taxes for any portion of the land that they occupied under that treaty. Successive governments over the years have tried to abrogate that aspect and tried to collect taxes from the people for land that they are not supposed to be paying any taxes.
I think that most of what's on the treaty will cover most of the problems that we're having. Again, the land is one of the biggest issues because we don't know where the boundaries were. So we're supposed to identify the boundaries. It never happened, but we'd like to revisit that offer. We acknowledge that a lot of this land might be personally owned, but I don't think all of it is at this point. I would like to reestablish the boundaries that was given to us, and then we'll visit to see who owns what and how they acquired.
So as a result, there is no legal clarity regarding Maroon land rights. Maroons have no recognized collective title to their traditional lands, which is still considered crown or state lands, while the government continues to issue land titles over Maroon lands to individuals without any respect for or reference to the Maroon leadership. These are very serious issues negatively affecting the survival of all Maroon communities in Jamaica. One of the most urgent manifestations of this structural issue is the granting of mining concessions over the ancestral lands of the Maroons in the cockpit country without their free, prior, and informed consent. Mining in the cockpit country presents serious threats of irreparable harm to the Maroons and their way of life. Mining will cause irreversible social and environmental damage while threatening one of the most valuable areas for biodiversity conservation. I'll now hand over to Mama G, who will provide an intersectional perspective focusing on Indigenous women's rights.
Indigenous women play a crucial role in preserving our culture. Since they are the bearers and keepers of indigenous knowledge, the structural issue that we have been discussing about the lack of recognition as a disproportionate native impact on indigenous women and our ability to pass down our indigenous knowledge from one generation to the next. We will start with a brief statement from Chieftainess Ronalda Pierman and priorities issues affecting indigenous women in Jamaica.
What are some of the major issues that is affecting Indigenous women today? Our right to our own bodies, our right to our own birthing experiences, and the right to teach our children the way how we traditionally do.
For the Taino and Maroon communities, birth and death are ceremonies. However, too often, Taino and Maroons are denied our home birth ceremonies. Home birth and natural births are outright discouraged by health and government officials. Indigenous women are often told that they must have cesarean sections. After birth at public and private hospital, many mothers are forced to give unnatural milk formula to our newborns and even deny the right to leave the hospital until they have fed the child the formula. Another major issue is the policing of the Maroon communities. In recent years, the Maroon communities of Jamaica have experienced increased policing by and conflict with the police, which the state have not sought to resolve. For example, in December 2014, 2 captains of the Charlestown Maroon Council were arrested and charged in Charlestown Maroon community by the police for possession and smoking of a small amount, minute amount of ganja. In November 2018, the colonel of the Charlestown Maroon and 2 captains of the Charlestown Maroon Council were arrested and charged in Charlestown Maroon community by the police for indecent language and malicious destruction of property, stemming from an incident in which the police attempted to shut down a Maroon event in a hostile manner, disrespecting the Maroon communities and the Maroon traditional leadership in the process.
I'll touch on the deterioration that we've experienced with our connections with the state. Collectively, all of the above has contributed to the continuation of the denial by the majority of the public of the existence of Tainos in Jamaica. And to many persons of Taino and Maroon descent feeling unwilling to self-identify as Taino and or Maroon due to fear of ridicule in the school system, the workplace, and the wider Jamaican society. This has contributed to a denial of recognition of cultural and intellectual property of Tainos and Maroons. Our community members fear to openly practice our traditions as it may be seen as obia and fall under the Obia Act of 1898. And they fear if they share with others about our ancestral inherited spaces, the government will seek to claim it because of what may be buried there. The Taino and Maroon vision of autonomy, consistent with the rights of indigenous people, as articulated in the United Nations Declaration on the Rights of Indigenous People and the American Declaration on the Rights of Indigenous People, is the ability of our communities to have our history, ancestry, rights, and leaders respected, our voices considered in matters affecting us, management of our communities and ancestral sites, and freedom to preserve and share our medicines, spiritual and cultural practices freely. In light of the above, we respectfully request the IACHR to call upon the government of Jamaica to recognize the rights of its indigenous peoples, the Yenkunkumpikibo Maroons and the Yame Taino, and to take the following actions. 1, recognition the indigenous rights of Taino and Maroon peoples in Jamaica in accordance with the AD-RIP and UND-RIP. 2, engage in meaningful and constructive dialogue with the Yenkunkumpikibo Maroons and Yame Taino with the purpose of initiating a process of truth-telling, reconciliation, resolution of our land and self-determination claims, and collaboration on issues of mutual concern. Adopt constitutional and legislative provisions to A, guarantee the rights of the Yenkunkumpikibo Maroons and Yame Taino to our lands, territories, and resources, and to protect us from illegal encroachment. And B, ensure that our communities can fully contribute to the development of the country and that our free, prior, and informed consent is required before any development or extractive projects affecting our traditional lands and resources are initiated. 5, establish a framework of engagement between the government of Jamaica, its ministries, departments, agencies, and law enforcement on the one hand, and indigenous peoples on the other, in accordance with Jamaica's international obligations. Refrain from the use of force. This is 6. Refrain from the use of force, harassment, and intimidation by law enforcement officials against Maroons and Taino people who defend our land. 7. Withdraw the Cabinet Office Directive and any public statements urging government ministries, departments, and agencies not to work with the Maroons or any group claiming to be indigenous, nor to sponsor any programs or projects that will include Maroons.
And apologize to Maroons community on these issues.
Muy bien.
Very well. That is all the time. So now in the second round, you will be able to conclude. Now, we will give the floor via our technological means to the illustrious representatives of the state of Jamaica, who will be presenting their positions via this means.
Hello, good afternoon. Are you hearing me? Thank you. First Vice President, Commissioner Esmeralda de Tluitinia, Rapporteur for Jamaica, Commissioner Roberta Clark, other commissioners, petitioners, good afternoon. The government of Jamaica acknowledges the decision of the Inter-American Commission on Human Rights to convene a hearing today to hear the submission of the Maroon Indigenous Women's Circle and the Yamaya Council of Indigenous Leaders, despite a request for a postponement. The submission has been perused, and the government of Jamaica respectfully requests that the Inter-American Commission on Human Rights permit us to respond appropriately in writing at a later date, given that the request for delay of the hearing of this matter was not accommodated on this occasion. Madam Commissioner, the Constitution of Jamaica protects the fundamental rights and freedoms of all Jamaicans and all persons in Jamaica under Chapter 3, which is commonly referred to as the Charter of Fundamental Rights and Freedoms. Notably, we believe it is important to highlight the following fundamental rights and freedoms guaranteed by the Charter. 1. Freedom of thought, consciousness, belief, and observance of political doctrine. 2. The right to equality before the law. 3. The right to freedom of discrimination on the ground of being male or female, race, place of origin, social class, color, religion, or political opinions. And 4, the right to enjoy a healthy and productive environment, free from the threat of injury or damage from environmental abuse and the degradation of the ecological heritage. In this regard, the members of the Maroon Indigenous Women's Circle and the Yamaya Council of Indigenous Leaders are able to exercise all of their constitutionally protected rights and freedoms, as well as all other rights established by the laws of the country. And we assert, therefore, that no claim of discrimination can rightly be made against the state. Notably, one Maroon community has in fact exercised its right to equality before the law by instituting a claim before domestic courts, which raises several issues that will also rise in the hearing today. This therefore means that the government of Jamaica cannot address these issues at this time before the Commission. And we again reiterate the request to allow Jamaica to provide submissions in writing at a later date, when the state is able to address the issues in a fulsome manner before this Commission. In the meantime, the government of Jamaica remains open to engage in meaningful and constructive dialogue with the Maroon Indigenous Women's Circle and the Yamaya Council of Indigenous Leaders to discuss their issues and concerns. We trust that the Commission will consider favorably the request for Jamaica to submit a more detailed response in writing. I thank you.
Thank you very much. Is there any other intervention? If there is no more intervention by the state, we will now continue with the hearing. We are taking notes of what the representative of the illustrious state of Jamaica has presented in order to respond in greater detail subsequently. With the continuation of this hearing, we will now give the Commission the opportunity to participate, to be able to have an exchange with you all. I will take the floor in my role as Rapporteur for the Rights of Indigenous Peoples. I would like to express my profound sense of solidarity with the statements that have been made in a claim in defense of your rights, and I will begin with the last statement by the representative of the government of the state of Jamaica, opening up to dialogue. Hearings as a tool that the Commission have this objective, a fundamental objective, to be able to place both parties in a position of dialogue. The petitioners have, through their requests, expressed the need to emphasize precisely this formula of a constructive dialogue, one that is respectful, trustworthy, in order to address from their experience and lives, from their communities. You have presented today this information to the Commission. On this opportunity, I would like to hear from you what your opinion is, what your analysis is regarding the impact that this has of not being recognized as the Taino and Maroon peoples, not being recognized as indigenous peoples. You have detailed the history of the formation of the peoples. So, what, according to your experiences and lives that you have had, and precisely in your efforts to have your rights respected, what are the limits and obstacles that you have found in relation to this lack of recognition of your status or qualification, being recognized or not as indigenous peoples? This would be one point. And a second question would be regarding the concept of the state's responsibility in relation to the compliance and fulfillment of the agreements and declarations and regulations in order to precisely give the indigenous peoples their rights to autonomy, to self-determination, in all of the senses and topics that make up part of your ancestral cultures, the issues of education, health, protection, environmental protection, and protection of territory, the evaluation that you all have made of the compliance or non-compliance by the state in this recognition of an identity, a cultural identity, and its autonomy and forms of governance in order to demand your rights. That would be to have this opportunity, and then my colleagues can use the floor and you will have time to respond. So immediately I will give the floor to the second Vice President of the Commissioner, Roberta Clark, in her role as Rapporteur for the State of Jamaica.
Thank you very much, Commissioner Arosemena, and are we in the afternoon? I'm still on Caribbean time, but I believe we are almost approaching the afternoon. Good afternoon to everyone here with us and also online, to the representatives of the state of Jamaica. I want to start off by saying how humble I am to be in this hearing and to listen to you very carefully. I think in a sense this is a historic hearing for the Commission, and I want to recognize that and also appreciate your own recognition of the first peoples of Jamaica, the Taino, as freedom fighters and as the first Maroons. I like that formulation of it. And also, therefore, also to recognize the Maroons, what we consider the African Maroons as freedom fighters. The first freedom fighters, I think, really across the Caribbean, or one of the first freedom fighters across the Caribbean, fighting enslavement and demanding their freedom and their autonomy and their equality and their dignity. And that is the history that you seek to continue in your current struggles and your current articulation of your individual and collective rights. So I just want to start off by saying that. There are some questions that I have, and I do also want to reiterate Commissioner Arosemena's request of you to maybe speak a little bit more about what are the obstacles that you're facing to the recognition of your collective rights. You did mention some cultural obstacles and also some legal obstacles, and the cultural obstacles which may also be grounded in the legal barriers that you face. So, for example, the criminalization, the colonial criminalization of cultural practices such as, you said, obia. So I also want to ask you, what is the status of that legislation? Is it current, and is it being implemented? Now, even when legislation is not being implemented, its very existence creates the possibility and the climate for discrimination and stigmatization. But I would really like to hear a little bit more about what is the status of that law, and what are your thoughts on how that should be addressed. I also want to recognize your demand for recognition of other forms of cultural practice in relation to how women's autonomy over their bodies and how children are raised, and the education, the nature of education to which children are entitled, education that honors the background and the history and the culture. Two questions. In relation to the question of right to land, to which you spoke, I know that there may not be a precise kind of calculation or definition of what that territory looks like, but what I would like to hear from you, what you estimate that territory looks like, and what has been the status historically of your claim to that collective claim that you have to certain parts of the land of Jamaica. What has been the history of that demand and the response of the state to that demand? And my second question related to something that you said towards the end of your presentation, that you wanted to enter the cabinet directive not to work with Maroon peoples. So I would like to hear a little bit more about that. That seems rather extraordinary from what you've said, and I'd like to hear a little bit more about that directive, as well as when was it formulated and how has it been implemented. And then in relation to the representatives of the state, and you did take us through parts of the Charter of Rights and Freedoms in the Jamaican Constitution, and you spoke about a number of individual freedoms, but my sense of it is that the representatives here of the Taino and Maroon peoples are not talking about individual rights, but collective rights, which they are articulating is encompassed in the UN Declaration on the Rights of Indigenous Peoples and the American Declaration on the Rights of Indigenous Peoples. Now, whilst these are not treaties and conventions in the way in which we understand that, the adoption or the participation of Jamaica in the articulation of these declarations may raise an expectation. And I wanted to ask the representatives of the state, how do they see these declarations applying to Jamaica and the articulation of the rights of Taino and Indigenous and Maroon peoples in Jamaica, as we've heard from today. Thank you very much.
Thank you, Commissioner. And The floor is on Commissioner Joel Hernandez. Thank you, Madam Chairperson. Greetings to the Maro Indigenous Women's Circle and the Yamaya Council of Indigenous Leaders. I hereby recognize this petition for a hearing that you made before this commission. This is a very important hearing for the commission, without question, for the rest of the indigenous people in America, as Commissioner Esmeralda Arosamena has mentioned. This hearing, of course, has a historic meaning that's very important. And thanks to you, a lot of the people here present, me included, have been able to know a little bit about the history of Jamaica. A history tightly associated with colonialism that for so many centuries dominated a region. And now it has to be recognized, has to be acknowledged, and we have to engage in all actions and measurements that the international community, through different international organizations, has been recognizing the indigenous people so that they can live the rights, the autonomy, the rights to autonomy as indigenous people. And history has determined that you are an autonomous people. I want to take this opportunity and this hearing as a start point for something very important. I hope this starts a dialogue. I have been highly motivated by the presentation by the distinguished representative from Jamaica, Nicolette Williams, because it has shown all of us, and it has been recognized here, that there's a willingness to engage in a dialogue, and a real, authentic, and constructive dialogue. That in itself is the main goal of these hearings, to start having a dialogue. Of course, it's a long way to travel, but at the same time, the way you have traveled to come to this opportunity and this moment has been long, but it's worth engaging in it and starting this dialogue with the state. Commissioner Clark mentioned it, the expectations that this generates, that Jamaica supported the declaration of the rights of indigenous people and the American Commission without even going into judicial analysis of these declarations. The mere fact that your participants and co-signers actually generates very, very important and strong expectations for the community in general in Jamaica and for the indigenous people, of course, particularly. I would like to have this declaration offered by the state of Jamaica in answer to this hearing. I think it's going to be very important for us to understand the entire issue. And very respectfully, I would like to suggest to the state, to ask them to explain to us how the state of Jamaica, as an independent state, comes from the British Crown, which supported the treaties in the 18th century involving the Taino and Maroon peoples in Jamaica. Because I believe that is a historic fact and a legal fact that's very important that cannot be ignored. I really hope that all this drives us in a direction that will take us to the basic step, which is the possibility of have you really exercise your right to self-governing. And starting from there, we have to have the recognition of collective rights also. It's clear to us that there's individual rights that are being protected by the Constitution, the laws in Jamaica, but we're talking about a different kind of rights. This is a different dimension, the collective rights. Thank you very much, Madam Chairperson. Thank you, Commissioner. And now we're going to hear from Commissioner Carlos Bernal.
I just wanted to acknowledge the importance of this hearing, and thank you for bringing us this matter to our attention. In the same line of Commissioner Hernandez, I would like to encourage the government of Jamaica to begin a serious process of meaningful engagement with the Maroon community for the sake of the acknowledgement of their rights. I am aware that Jamaica is not a party of the ILO Convention 169. That's a fact. However, within the realm of the Inter-American System of Human Rights, and also within the realm of the Commonwealth states, there has been a huge amount of progress in the recognition of all indigenous rights. For instance, it is not, we cannot underestimate the importance of the two cases, MAVO 1 and MAVO 2 in Australia, that acknowledge the rights of the indigenous people of the peoples of the Northern Territories. And right now, as many of you know, in Australia, there is a huge discussion on the proposal of the so-called The Voice, which is an initiative to entrench in the Constitution the rights of indigenous peoples in Australia. So in the Commonwealth, in the realm of the Commonwealth, there is the recognition to reinvigorate, as a matter of justice and fairness, the recognition of the indigenous rights and to enhance the protections of the rights at all levels. So I think this implies a unique opportunity for the current government of Jamaica to make justice to the Maroon community and to at least to engage in a minimum in a process of meaningful engagement with the community to address all the issues. Now, having said that, I just would like to ask one question: is whether the petitioners and also the state can give us a little bit more of information about domestic processes and initiatives of that meaningful engagement, whether there is any, I heard by the representative of the state that there is a case pending in court. Can we get more information about that? And also I would like to know whether there has been any process that has been initiated either within the realm or the framework of the Parliament, and also concerning the role of the public administration. I would like more information about that. Thank you so much.
Thank you, Commissioner. I don't know if the Secretariat has a participation here. Yes, thank you, First Vice President. Welcome, everybody, to this hearing. Firstly, we want to mention to you that today, present here, there are students from this university, and I'm sure that for the first time, they have access to this dialogue, this conversation. They're hearing for the first time about the indigenous people in Jamaica. What you have done today is also to show to all these people, these young people who we want to get involved with the system. You have shown them what's happening in certain countries belonging to this region, something that we very seldom hear about, or we don't turn our attention to them for different reasons. Now, I have a question, and I would also make a comment. December of 2022, the Inter-American Commission on Human Rights published the text, "The Right to Free Determination of Indigenous and Tribal Peoples." We would like to give you this text. It's in our website. It's both in English and available in English and in Spanish. But we want to refer to this, to use it as an important instrument to be used by you. This has compared experiences of all other indigenous people in the region in their struggle to assert self-governance about the land, their structure, their culture, and the life forms. It will be very important for you to have this. We also want to address the representative of this state that we are awaiting for information, all the information that you have offered to send us in writing. But we also want to offer this representative from the state time and effort to have a common effort, something that will also incorporate and include the representatives of the Taíno and Cimarron people. We understand that the Jamaican Constitution protects freedoms and rights, and there is a formal prohibition against discrimination. But I also understand that those people who are here today are not talking about a legal or judicial prohibitions, but an everyday discrimination. My question, therefore, is, could you please explain to us a little more detail the effects of criminalizing your cultural practices, defending the right to your land, your way of life, and your self-governance? Can you tell us about your experiences, some of your experiences, so that we can get closer what the representative of the state is talking about, the prohibition of discrimination, and also the daily discrimination you suffer. Thank you, and thank you for the ritual starting this hearing, which it's been beautiful. It has excited all of us. Thank you. Thank you, Secretary. Now, the special repertoire of the socioeconomic and environment declaration has the microphone. Thank you, Madam Vice President. It is such an honor to be present here as part of the participants in this hearing, to hear your testimonies. I have two specific questions. Given the importance of the indigenous peoples in America and the world fighting the weather change, we want to know what's your participation, what's your role trying to help Jamaica to fight against these climate changes, using your cultural practices and your knowledge about nature. How do you protect nature? And I would like to hear more, probably get more information about your fears about the intellectual property, the cultural rights, how you are being affected, or your rights are being affected. And also put in the radar the Inter-American standards and the resolution about a climate emergency. I believe that's a very important instrument for you and for the entire indigenous peoples. Thank you. Thank you. Well, now the petitioners will have the floor, and I want to hear, I know we have limited times. However, any information we cannot complete or obtain today will be very useful in the near future if you can send it to us in writing.
So we will respond to the questions of the commissioners. Could you remind me of how much time we have to respond, please?
You will have 10 minutes.
Very much, commissioners. I'd like to start first with a statement of support on the question of recognition, and immediately after that we will respond to the specific question about the impact of the non-recognition of Indigenous rights in Jamaica. So I hand over the floor for a statement of support.
Muchas gracias. Estamos aquí.
As we have said, we are here on behalf of the International Council of First Nations, a council which was formed in 2018 during the Permanent Forum on Indigenous Matters in the United Nations, with the indigenous peoples who came from all parts of the world to present their ideas, their complaints, and especially to seek an alliance with other peoples to be recognized. One important point is that we recognize that based on the recognition which sometimes we request or we want to be given, the important thing is to have the recognition amongst ourselves as peoples, which is taking place. So the groups that we represent, groups on all 5 continents, we are 100% behind this effort by the Maroon and Taino people in Jamaica, because we see them as an example, a model of what can be proposed that can be followed in many other places with the peoples of Mexico, the United States, and South America and Central America. And everywhere we all are in the same situation. In this sense, we are greatly thankful that the idea of the rights of the First Nations, as we call them, indigenous peoples, has been taken more seriously. And one of these rights that we are seeking is to have recognition. In addition to cultural elements, we have cultural, even territorial elements, but not legal elements. So we can't change things as they are on our own. That's why we are here with you all to extend our hands to all of you as if we were all one person. And this matter of the environment is very important, because the only way that the environment can be straightened out, sorted out, is by the guardians of the land, of the earth. Unfortunately, in more than 500 years here on this part of the globe, our peoples have suffered, but an important thing is that we have never fainted. We have never given up. We are still on our feet. But especially we have the greatest disposition and availability to unite our efforts and to remove the things that divide us from one another, and to seek sovereignty especially. So it's very important to me on this day to share that we are here on the day known as Seven Crocodile, in a time of the last 5 days of what we call the Aztec calendar. These are special days. They are days for reflection, adjustment, and balance. So today we are honored to be here with you all, and our chief representative, also with the traditional name of the crocodile or alligator, Caiman. So we support all of you. We support you 100%, but we want to join hands with you all. There's another situation that I think is very important, which is these sacred elements. For instance, we have sacred things here that have been given to us or left to us, or we have inherited, but often we have issues crossing borders with these things. They try to treat it as if it were luggage. But as I mentioned, we are more than willing to improve this world so that these young people and other young people who are hearing us in other places will know that we have that right and responsibility. So again, I'll say on this day, this is the beginning of the Nemotemis, the 5 days for reflection, for seeking balance and adjustment in this conference at this time. So time is on our side. Time is our greatest friend, but time is not going to wait for us either. Tlazokamati, thank you very much.
At large for the Garifuna Nation.
Okay, as Ambassador at Large for the Garifuna Nation, and also my brother representing our president, we stand close with the Taino and Maroon people, and we have taken the initiative around the region of the Caribbean to establish what is United Maroons and Indigenous People. Garifuna Nation embraces Garifuna people all around the world. There are 1 million of us around the world. And the uniqueness of Garifuna from Belize is that we are a bridge between other indigenous people like the Maya. We have almost 1 million Maya people living here in the United States. So we offer the support, although it is a specific discussion for the people in Jamaica. We are one, we connect as one, and we give the support. We have had conversation with CARICOM this morning about sending information about this hearing around the region and around the world. And our intent is to take the conversation as indigenous-led, with no disrespect meant, but defining the protocols of what it means to be indigenous. Finally, that we will be honored, respected as peoples. We are not considered peoples, we are considered cultures. So when the Taino and the Maroons in Jamaica suffer, we suffer too, because they are our relatives. This is a healing journey for us.
Thank you very much. So we have about 5 minutes left, and I will invite Mama G to address the question on the non-recognition of Indigenous people in Jamaica and what it means in terms of obstacles.
Yeah, greetings again. The lack of recognition as Indigenous people has really taken a big impact on us. It stops us from moving forward in doing the work that we are commissioned to do. As stewardess of the land, we cannot able to carry out the work in dealing with the land climate change the way we are supposed to because of lack of recognition. Some of the areas that we should be working with, like the forestry department and these things, we are not a part of these things. We are not a part of the land commission or any one of these things, you know, because of lack of recognition. Because of lack of recognition, we recognize that there's a domestic case up to the time, but we could not stay just to deal with that domestic case if we are not recognized, as it was said in the review to the United Nations third report, as a people. There's nothing for us to exercise in our own country domestically if we are not recognized by them. So that's why we are here today, you know, to take it on this level, because we need recognition from our own people, where the history has born and live and where we are. If we are not recognized domestically there, then where can we go? You know, so the impact is very big. It also brings an impact between our own communities where we have conflict and disputes because of the lack of recognition. There's dispute even amongst our own people in the different Maroon communities also.
Yeah, to touch on that briefly, I think it should be said on the record that the community that has the case with the government of Jamaica is not one of those being represented here now today. And one of the consequences of that court case is that we are there are certain levels of engagement that we would have had previously, which have been revoked, such as the cabinet order that was issued stating that any community that is stating that they are Maroon or indigenous, that they have to check with the Attorney General for funding that they would have normally had access to. And the only reason that these things would be an issue to us now is because there's nothing in law that constitutes our rights. So they can put out these cabinet orders, and then it creates this fear amongst the government officials on should we continue to interact with these communities or not. I wanted to just state here clearly that, you know, obviously Yame Taino under the Yame Wani Council and our membership are indigenous people of Jamaica, and our relatives, the Nkunkung Pikibo, which are the Maroons. And today for us is Koni Kishibu Kati. It's a full moon of abundance. And we are determined to correct the colonial narrative of Taina extinction in Jamaica. We want the record to show that we acknowledge that the issues presented here today were inherited by an independent Jamaica, and so too the current administration. This hearing was never Waikoil and the Maroon Indigenous Women's Circle versus the state, but has always been Waikoil and the Maroon Indigenous Women's Circle seeking assistance to correct the human rights injustice our ancestors have been subjected to, and that subsequent administrations have ignored until today. So these are not issues that have just arisen, but because there has been nothing legally put in place to protect our communities, they continue. And we are willing and able to respond to the rest if the time is not allotted here in writing.
Muchísimas gracias.
Thank you very much. Immediately, I will give the floor now to the state of Jamaica. They will have this time to present their final opinions.
Okay.
Yes.
Very much. Thank you very much, Madam First Vice President. We have listened carefully to the statements made by the petitioners, and we have taken careful note of the comments and questions posed by the commissioners. And just as we had indicated earlier, we will revert in writing in the appropriate manner. Thank you.
Muchísimas gracias. Muy bien, entonces.
Thank you very much. So we're going to end this hearing. I would like to express my thoughts as in my closing words. The importance, which was mentioned by one of these individuals at the table, the importance of you having the support in the Inter-American Commission and have this cooperation, technical cooperation, to seek formula which will allow us to work together to help you in this process. It was also, they also mentioned our thematic report about the free to self-determination, self-governance. I want to emphasize that because this was the result of arduous work where a lot of people, a lot of representatives from different peoples, indigenous peoples, had the chance to express to us all of their ideas. And we also had the chance to hear some to some members of the organizations. Now, this report recognizes the history that you have shared with us today, that the treaties from the 18th century actually recognize your rights. That is there. It's been recorded. I believe that Commissioner Joel mentioned that in detail about the fact that that is current. The treaties from the 1800 current, and these are norms and regulations that maybe can be implemented in the present. Therefore, we want to offer any help for technical cooperation, the repertoire of indigenous peoples. Maybe we can organize meetings, different sessions, to go into further detail about formula and mechanisms that we can adopt to have an effective work to make your rights a truth. We want to thank you from the bottom of our heart. Thank you for the work that you are engaged in, your serious commitment to your communities, to your peoples, and that is that's an important element, important for the defense of the human rights. It's necessary to have you here. Thank you very much for your participation. Thank you for sharing with us all your testimonials or your ideas, and for continue working the way you have presented to us, seeking this communication with the state, which is crucial to be able to establish this dialogue, a constructive dialogue and productive dialogue, so that we can achieve better results. So again, thank you very much for your participation. Thank you for your presence. Thank you. Thanks to the audience, of course, for being here present during this hearing. Thank you very much.
Recording.
día. ¿Cómo están?
No te escuché. ¿Qué dijiste? ¿Qué dijiste?
Buen día, ¿me escuchan?
Sí, te escuchamos por aquí. Hola. Buenas. Buenas tardes. Buenas tardes. Déjame prendo esto.
And if I'm going to be honest, I believe that the Ministry of Culture, Gender, Entertainment and Sports is very heavy for one person to be organized. With all of these issues that is coming up with climate justice and indigenous rights, they need to have a separate Ministry of Culture and Indigenous people that somebody else is dealing with, and someone else can deal with gender. I don't know if gender, entertainment and sports fit together, but that is another discussion.
Yes, I know. Bob's a great job a lot.
Yeah, a lot on plate. So it's not that we're knocking them. What we're saying and have repeatedly stated is that this is an inherited issue. And some issues, when you step into a position and see this big mess, you try to look for the things where you can fix up instead of troubling the big mess. And what we're saying is that the mess is getting worse and worse on its own, and we need to pay attention to it. And if you can do it, let's go internationally for support. It's not that we're enemies. Let's get the support to fix this mess, because with the issues that they're talking about with climate change and food security and what we saw with the pandemic, they need some indigenous medicines, they need some sustainable food, they need some examples of sustainable communities that can share with other communities in Jamaica. Imagine if all of the Rasta communities was developing themselves from the Maroon communities and Taino communities, and what they call indigenous cultures were sustainably living, so that they were bringing in funding from tourism, and they were able to create their own markets to trade and exchange. You don't have nothing to lose. All of this is to benefit the country. So we really would like to know, why is it this resistance to acknowledge us as indigenous with nothing to lose?
Question two is you're quite young. You're elected leader. How does you represent the Taino people? How does you become the selected leader?
Oh wow!
Chief?
All right. So in 2019, I had my investiture ceremony, and how that happened, here being in the Tonga Nation lands and Chumash territory, is because I participated in a run representing Jamaica called Peace and Dignity Journey, and that's connecting with indigenous tribes, and I met some Taino elders from different communities, and they said it was time, to deal with a lot of prophecy. They said it's time for that resurgence in Jamaica, and where I learned about my indigenous ancestry, not something spoken of mostly. That's another impact of these rules and these laws. So in my own family, they said that I have Maroon Indian ancestry, and my grandmother said that she told her father not to tell anybody that he had that. So when I started to connect more with these things, that I started to learn about it. And as a result of that, when the elders said that we need to resurrect this in Jamaica, one of the things that we need to find was an elders council. And I think people say time doesn't exist, and I have to do so many to find an elders council. But just as the elder said, that these people started to pop up, and when the elders started to pop up, there were ceremonies that needed to be done, because now we're bringing back a tradition that was dispersed. We're bringing back people that was dispersed. Our last year when we had our New Year ceremony, the theme was dispersed but not disconnected. So it's really an anchor bringing everyone back together. So to answer your question in short, it was ceremonial. It was a lot of things happened, just like you were teaching here. That I can't explain other than it was creative. For a brief example, one of the things that I had to do was a totem came out with the hummingbird, and the person that was making my preparing the ceremonial thing for me said that I needed hummingbird feathers, and I said I don't know how I'm going to get hummingbird feathers. And it's interesting that we're here, and Mazatsin is here representing the Mexica people. When I was doing the prayer run in Jamaica.
Estimadas, vamos a comenzar en unos minutos, si pueden empezar. Dear colleagues from my right-hand side, we are starting soon, so if you are not staying in the room, because we need to start a new hearing. Thank you very much.
It was something that just had to happen. My time on that I got at my investiture is Kaiman, and I heard my dad say today is the day of the crocodile. So mystic.
Thank you.
Well,
what we are doing?
No, it is Garifuna Nation time. It's not our time. Our mission finished. Yeah, let's go. Yes. Leave our stuff.
Before we start officially, interpreters, can we test the mics?
This is the English booth, testing the English.
I salute the delegation of the illustrious state of Colombia and the distinguished representatives of the alleged victims. I declare the public hearing of the case 11.888 Alfredo Acero Aranda and others, Red de la Amanda, regarding Colombia, open. The Commission states that according to its rules of procedure, Commissioner Carlos Bernal Pulido would not participate, cannot, and is not participating in the hearing of this case due to his Colombian nationality. I will now give the floor to our Executive Secretary, Tanya Renault. Your pardon. And I greet the ambassador, Your Excellency from Colombia. We recall the days when you were with us, normally sitting on this table. Very so nice to see you. Thank you for being present.
Gracias,
Thank you, Chairperson. Congratulations to my sister Esmeralda. Thank you, Chairperson. Good afternoon, Ambassador, and the presentation of the petitioners. And good afternoon to the representatives of the state, this case. With the alleged responsibility of the state by the alleged extrajudicial killings and woundings in prejudice of multiple individuals by public agents in the beginning of the 1990s in Barranca Bermeja, allegedly the result of the actions of a military intelligence network of the National Army, as well as the situation of impunity of said facts. On April 14th, the Inter-American Human Rights Commission approved the report of admissibility number 12-16, in which it declared the petition admissible according to the provisions established in the following articles. Various articles of the American Commission, in addition to the other articles of the same legal instrument. This hearing has the aim of hearing the testimony of a witness going into the information and considering the information regarding the case. The floor is yours, Chairperson.
To begin with, the Commission will hear testimony of the witness, Aliero Oribe Munoz, offered by the petitioners. I beg your pardon, I'm away. The witness will testify on the facts of the present case, on the alleged investigative obstacles, the alleged lack of guarantees surrounding the criminal investigation, and the alleged findings on the operation of state intelligence as a mechanism of persecution against human rights defenders. The petitioners will have up to 10 minutes to conduct their examination. Subsequently, the state may question the witness also for up to 10 minutes. Finally, the Commission would then proceed to ask questions. The declarant, who is the declarant? And where?
Sí, estoy presente.
Yes, I am present, Your Honor.
Could you please state your full name, place of birth, and
Yes, my name is Aliero Munoz. I am an attorney. I worked with a collective of attorneys for several years, and currently I am a Congress member representing the chamber in Bogota. I was an attorney of this case at the time.
then could you please, do you swear or promise to tell the whole truth and nothing but the truth?
I don't have the translation, but yes, I commit to say the truth regarding the facts.
The floor to the petitioners to proceed with their questioning. You have 10 minutes.
Thank you very much, Madam Chairperson. Good afternoon to all of the commissioners, and greetings to the Director of the Legal Defense Agency. I am an attorney with a collective of attorneys. Good afternoon, Doctor. We would like for you to please tell this hearing the work that you performed regarding case number 7, regarding the Army Intelligence Agency, and what were the obstacles faced by victims in the actions to seek truth and justice. Well, in the years when I began in 1990, in the decade of the 1990s, I had my office of attorneys with the Attorney Collective in Bogota. But the attorneys, we were distributed in order to handle cases of severe human rights violations in various regions of the country. I was in charge of Magdalena Medio, and more specifically, Barranca Bermeja, which was an area with many social organizations, with much social movement, with unions. There was a scenario which was historically had much violence by armed groups from the guerrilla fighters. At that time, I was working with CREDUS, which was an human rights organization regionally. And in that work, in the media, in the La Prensa, the newspaper, was published the testimony of two members of the intelligence groups of the National Army, in which they stated that they had committed a series of massacres, murders, and attacks against various citizens. With the participation of CREDUS at that time, the family members were organized of the various victims. Some of those victims belonged to labor unions, rural farmer associations, human rights associations. Also, there was a journalist and other social leaders. And I was working as attorney for the victims for this case. This case was the first approach that I had more or less 29 years ago. The first encounter with these networks of intelligence and the way in which hidden operations, which translated into severe human rights violations, were carried out with the dirty war. And via these reports and denunciations, several investigations were conducted. These investigations compromised members of the National Army and members of the Directorate of Intelligence, which at that time was directed by Colonel Rodrigo Quiñones and a Captain Alvarez, who was the person directing the network in Barranca Bermeja. At that time, various investigations were initiated. The first thing that should be said is that the first obstacle to justice was the criminal military justice system, because cases were processed before the criminal military justice system, specifically before the courts of criminal justice system of the first instance and the military authority, despite the fact that there were confessions from the members of the army themselves, and despite the fact that there were all of the dead and victims from the massacres and all of the facts that had been properly legally registered, there was a competition between the ordinary justice system and the criminal military justice system, and the Superior Council determined that the criminal military system had to carry out this case, as occurred in Colombia at that time, when proceedings, when the parties responsible were military and there were civilians, as in this case, because the intelligence network number 07 had direct members of the state and of law enforcement, but also they had collaborators and informants and hitmen who were paid by the state, who were on the reserve account of the military forces, and they were under the jurisdiction of the criminal military justice system. And the proceedings were carried out, and impunity was guaranteed at the time. This took place in relation to the criminal investigation of state agents. I am speaking about various colonels, at least one colonel, several majors, Major Rafael Colon, these names I'm mentioning, captains, sub-officials, all of whom were left in impunity through the criminal military justice system. In the ordinary justice system, the hitmen were investigated, that is to say, members who were contracted by the 07 network, who via the intelligence services activities to carry out the extrajudicial killings. But there was also an obstacle there. At that time, in Colombia, there was the secret justice system, what was known as that at the time. In other words, judicial proceedings were done before secret judges, secret attorneys general, prosecutors, secret witnesses, secret prosecutors, and we would litigate from behind a mirror with voice distortioning technology. There were never public hearings. There were not public jury trials. And practically what we were doing was introducing information, but there was not true participation by the victims. In fact, at that time, the victims were not recognized, and we had to do actions before the Constitutional Court to be accepted as representatives of victims. We had to be declared guardians. So there were two rulings in the secret justice system. In other words, in what appears in the proceedings as regional courts and the national court. But our participation there was very limited. I insist, because we did not know who the judge was, who the magistrates, the prosecutors, attorneys general. There were rulings against the material authors of crimes, but investigation was never made into the determining members of the network. The director who was receiving the reports, because there was a search that took place in Bogota, a research, and in the reports were found. There was a massacre, and the following day from Barranca Bermeja, they would send to Bogota via fax the report of the facts, events, and the crime that had been committed. In addition, in the disciplinary proceedings, these were processed in prosecutors' offices where the aim was for these public servants to be destitute, to be removed, but in these disciplinary proceedings, there was only a sanction one time in the first court of first instance, which was severe repression. There were two prosecutors' offices, one for human rights, which was ours, which we wanted to bring proceedings, and the prosecutors' offices for military personnel. And in the end, the proceedings were prescribed to and decreed by the prescription according to all of the members of the public forces and law enforcement who participated in extrajudicial killings and massacres committed by the 07 network of the Army. In the demands of direct reparations, the demand for the direct reparations, likewise, the rulings were contradictory. The contentious administrative affairs court for most cases denied the requests. In other cases, they ordered reparations for victims, but in the court of second instance, the State Council of Colombia revoked the rulings, of the guilty rulings, and the absolution rulings were supported with the argument that there had not been a criminal ruling against military personnel, despite the fact that there were thousands and thousands of files with the testimonies of relatives, of the facts and events, the testimonies of those who were reporting before different authorities at that time as well. One obstacle was the attack against the attorneys and the attack against relatives and organizations. At that time, I suffered many threats of death. I had to leave Barranca Bermeja, and I could not continue to bring these cases in 1997 because I was going to be murdered. Then when we published in our book in 1999 about these facts, I was threatened. They called my house my daughter. They made several threats and harassment events. The network of the Army as well had made an attack and murdered Blanca Cecilia, who was the secretary of Credus. And they had confused her with the woman who was the president, Quiroga. She had to forcibly leave Bogota. She was displaced. After that, the following president, who was the president of the organization with which we collected all of this information to bring the case in the judicial system, also had to leave the country because she was going to be murdered as well. All of this is to say that there were obstacles, there were threats, but in addition to those, the witnesses were murdered. The two first witnesses who reported everything, who had left the country, the public authorities convinced them to come to Colombia. They came. and following that they were murdered. At least 6 members of the network were murdered to hide the truth of the events. Thank you very much for your testimony, such a rich testimony. Our chairperson has announced that the time is up now for the representation of victims. Thank you very much.
Thank you very much. Actually, you have exceeded by 1 minute and 8 seconds. And so I will have to offer that 1 minute and 8 seconds to the state. I now give the floor to the state to question the witness if you so wish. If you so wish, 10 minutes.
Sí.
Good afternoon, commissioners, Madam Secretary, petitioners, Ms. Lydia Uribe, and everybody present in this hearing. I want to ask you, how can one assert from your answers an important subject, the intelligence and counterintelligence in Colombia? Could you please illustrate and inform the commissioners as to what is the regulation nowadays existing around this subject?
Señor, ¿está usted sin audio? ¿Podría activar su micrófono, por favor?
We're asking him to activate the microphone because we lost video and audio.
Perdón, me lo bloqueé. Sí, respondo su pregunta, doctora. Sí, efectivamente decía que en la legislación actual hay una ley estatutaria que es la que regula hoy las actividades de inteligencia. Para la época de los hechos no existía un marco regulatorio.
You know, there were manuals that the public organization was using, and there were some national doctrines which considered that the civil population, the social networks living in this context, like the one in Barranca Bermeja, were supporters or people aiding the guerrilla. Now, the subject we have to criticize here is that intelligence used that information they would collect on people, and instead of submitting that to the due process, if they consider there was any connection, of course, from my point of view, they didn't have any connection to this. They were just social leaders. However, they would execute them. They would be sentenced to the death penalty through the intelligence they had, which was directed by the members of this network, at that time ordered by the Navy. Many years later, we found out that they had over 41 networks involving all the military forces, like the 007 force. Thank you, Dr. Uribe. May I continue? Do I have time? Doctor?
To do this. You've used up 2.5.
Muchas gracias.
Thank you. Dr. Lydia Uribe, could you please tell the commissioners here present, what's your opinion about the so-called theory of the internal enemy? Well, this is a theory that was operating and implemented within the Colombian system, whereby, with the idea of removing the water from the fish, as we say, in areas like Barranca Bermeja, they thought that since they were far and the Popular Liberation Army were present, the state considered that the social organizations living in those areas, in this case in the city of Barranca Bermeja, they would immediately assume that they were accomplices, they were aiders or abettors, or they were coordinated or associated somehow with the illegal and illicit armed forces. Those security doctrines were called as the National Security Doctrine. And we found in several reports multiple manuals they issued, and where they opined that in order to get rid of the guerrilla, it's not only enough to capture and kill the guerrilla members, but also their other opponents. They said that organizations like Credos were part of that structure, alleging that they were supporting the guerrilla. And that's why when they created network intelligence networks like 007, they do it with the idea of attacking terrorism. However, what they really do is these undercover operations, dirty war. Why would they have hire assassins? In the case of Barranca Bermeja in previous years, they killed union leaders. And that was done by Army members, by the Navy members. A lot of cases, like the one of Gustavo Chacon, were proven. We found out that he was a union member and killed by the Navy. They corrected this by using certain individuals as if they had been the perpetrators of the crimes ordered by the intelligence organization, and the information would be gathered by the intelligence agents and intelligence analysts. Thank you, Dr. Uribe. And I want to ask you, after assessing the different processes that you knew about regarding the intelligence network, part of the Navy, what is your conclusion, your final conclusion, after having analyzed these cases? Well, firstly, the under officers who report these initially, among other things, they reported because they were going to be murdered. So at the end, they ended up being in custody and eventually being murdered. In fact, one of them murdered in jail. The military forces, both criminally and as a discipline, they were impugned, untouched. Impugned because the military court found that there was no evidence that what the under officers were saying was true. And regarding the disciplinary area, they stopped the investigations and they ended all these investigations because they got to their expiration time. They found that some of the hired assassins, some of which were captured when they were perpetrating the crimes, or who were actually reported by members of the network, some of those were also murdered. Some others were sentenced in the secret justice, as we call it, by the regional justice and also the ordinary justice. But we can say that this impunity, I mean, justice never touched the material authors. Some of them were never captured. Thank you, Dr. Lirio Uribe. Madam Chairperson, with this last answer, we finish the questioning by the state.
Very much. Now the Commission will proceed to ask questions of the witness. And I invite Commissioner Joel Enriquez Hernandez, rapporteur. He's the country rapporteur for Colombia, and he starts.
Gracias.
Thank you, Madam Chairperson, and thank you to the declaring the witness in this hearing. I have a question for you, a specific question for Mr. Alirio Uribe Muñoz. This question is, I want to invite you to tell us what do you know about the existence of sentences about the perpetrators or the people who were responsible of these murders, the murder of these victims in this case. And additionally, in connection with the aforementioned, I want to know if there was any reparation for the victims of these murders. Yes, Your Honor. I would like to clarify several points. As I mentioned before, there were no sentences of military personnel, but but the informers, collaborators, and also hired assassins. Yeah, there were sentences against Carlos Alberto Maya and Cesar Castaño, were both sentenced. They were accused of having committed 10 of the homicides at that time. There was another sentence against Felipe Gómez Lozano, against Miguel Antonio Bran Cáceres, Julio Ernesto Prada, and Estela Osorio. They were also hired assassins, and they were accused of homicide. So the total was about 21 people. Also sentenced was Miss Estela Osorio for the homicide of Mr. Cáceres. And there was also a sentence against Alberto Robledo. Apparently he was the material perpetrator of this, and he was sentenced for 7 of these cases. Now, Your Honor, I want to highlight the fact that these sentences were against the material actors of these crimes, not against the public officials in this network, nor the people who were ordering or paying the assassins. Regarding direct reparations, all the families applied for direct reparations. They went to the courts in Santander, and they also went to the state council. Inexplicably, the sentences in the lower court were contradictory. Some of them were exonerated, some of them were found guilty. However, they were all appealed before the state council. And the state council, in quite an arbitrary way, in my way of seeing this, they found that because the military criminal justice had stopped all proceedings against Coronel Rodriguez Quiñones, against the rest of the mayors, captains, the under officers of the intelligence network, they found that the criminal evidence was inexistent or wasn't enough to be able to remit them to process. In fact, they mentioned that these assassins were not state agents and that these sentences were about pertaining to the assassins. So the criminal impunity affected, in fact, the reparation action. So the states alleged it was mere rumors and there was no evidence, but there were declarations, there were statements from the members of this network, from civilians who had been sentenced. They were acknowledging, in many cases, the crimes, the commission of the crimes. And the state council decided then that the state didn't have to answer for the crimes committed by these assassins, civilian assassins, and that it hasn't been proved that any state agent had participated. That goes against thousands of judgment that say otherwise. One thing is the criminal liability, another one the disciplinary liability, and another one the failure of the state when state agents are the ones acting or creating these crimes. That is the current situation. So as far as I know, none of the victims, or maybe one single case, which was not appealed. It's a family, and I don't remember, since I didn't represent them during the reparation. There's a single case where there was a sentence that was not appealed, but the rest of the cases, so the majority of cases, there were no financial reparations whatsoever. Nobody acknowledged any responsibility or participation. There was no apology to the victims from this network created by the state, which worked in an undercover way in Barranca Bermeja during those years.
Call on my sister Esmeralda, the first vice president, to put questions. One, I hope.
Yeah.
Thank you very much, Mr. Uribe. 2 questions. In a very general sense, you have been specific regarding many aspects of the investigations and the events. But according to all of your analysis, what constitutes, according to this analysis, the primary findings that at an internal level, in the context of these criminal investigations, occurred in relation to the operations that were conducted by this Network 7 of intelligence of the Army? That's one question. The other question, toward the end a bit more, how do you evaluate the procedural status of the various criminal proceedings that are being presented to clarify the events? How does that situation look currently now? Yes, Your Honor. I will respond regarding the findings 30, 29, 28 years ago. I, as a human rights defending attorney, it was very impactful to understand the dimension of what was implicated by military intelligence, in this case, the National Army, conducting undercover activities in an area where they believed that the population was an insurgent population, or the civilian population was supporting the guerrilla fighters. They had their analysts, their intelligence officers, they paid their informers, they paid their support network, they collected information. The oil union believed that it was a union belonging to the ELN. Credus, they believed because it was a human rights defending organization that it was supporting people who were detained and criminalized at that time by the secret justice system. Credus, they believed, was also an arm of the insurgent forces. They believed Credus was an organization that had an assembly of over 500 people, and they said all of those people were a support base for the insurgent fighters. There was a transportation worker union. There was a massacre in Villar, I believe, where they were against that union. They turned off the lights and they entered with machine guns and pistols and murdered all of them. In that fashion, it was impactful to me to discover the materialization of a philosophy of the internal enemy against the civilian population, seeing this population as a legitimate objective of these undercover operations of the dirty war. I emphasize this information came into public light because it was told by the agents themselves, the intelligence officers who were then murdered after that. The intelligence agent by the following names. These intelligence agents had problems because they had refused to commit certain acts of murder, and they had orders to be killed, and when they realized they were going to be killed, then to protect themselves, they turned themselves over to the prosecutor's office, and then they told everything that they had been doing to seek protection. They left the country. I emphasize, then they were convinced to come back to the country, and then there was record of what they had said. They retracted what they had said, and then one of them was on December 31st was murdered. That was impactful to me because that was the New Year's Eve, a festival, a party day, and the news came out in jail. He received several gunshot wounds, and the gun was left on his chest.
Interrupt you, but we have very little time left, and almost everybody on this table wants to ask you a question. And they have a right to ask you a question. So if you could end your answer there and listen to their questions one after the other and then answer all of them. Could we do that? Thank you. I next invite my sister, the second Vice President, Commissioner Roberta Clark.
Thank you very much, and good afternoon to Senor Munez. You outlined a very horrific and fearsome story of impunity, and I think you've outlined it very clearly and well. I am more concerned now with how you characterize the actions of the military criminal tribunal, whether you consider having regard to the evidence that the tribunal had before it acted improperly, and have there been any recommendations for accountability on the part of the Military Criminal Tribunal? Thank you.
And then, can we ask the next question? You didn't get the question?
I need translation, please.
Oh.
Señor, usted tiene la
You have the interpretation on the icon, which should be... I've clicked it several times to receive the interpretation. I set it to Spanish, and I still hear it in English. Now we will sort that out. Meanwhile, we can have the rest of the commission ask their questions. Thank you very much, Chairperson. Good afternoon, Dr. Uribe. I have very specific questions. The events are quite clear. I would like to ask you first if you believe that these events and actions constitute a form of more general pattern of action regarding these groups, this doctrine, criminal doctrine of the enemy. Secondly, the issue of the unit of reparations for victims, if any sorts of reparations have been given to victims. Finally, the topic of threats that you have suffered, you and your family, and the families of victims. If there was any sort of process or response. Finally, we talked about statutory law. Would this law exist? Do you believe that it had an impact, a definitive impact on changing things or not? Thank you.
Gracias.
Thank you, Chairperson. I would like to very quickly ask this question regarding what you mentioned of certain different obstacles in the investigations. There have been several of them. If you could indicate what the main ones were, the main obstacles to criminal investigations on an internal level, that would be my question. Thank you, Madam Chairperson.
Question I will not take up time I gave to the Executive Secretary to ask a question.
Muchas gracias.
Thank you very much, Chairperson. Good afternoon, Mr. Uribe. Very quickly, we understand from what you have stated, the sentences in the criminal military field did not have the result of guilty rulings, but in the civil courts that you referred to, you said there were some regarding the material authors and informants that were described in these sentences, the modus operandi that you mentioned, and the connection with the public authorities. And I would also like to ask if you could go deeper and specify the obstacles. Has this been of a procedural nature, a different nature in the context of the procedures and in the ordinary justice system? Thank you very much, Chairperson.
Next, the Executive Secretary.
No, I'll defer.
Thank you. Mr. Uribe, you have not many minutes to give to us because we are out of time, actually. So if you could just deal with each of the questions by points, then you can send your answers later in writing to us, more detailed answers. Okay? Then please, if you could just give us little points in each of them, and then send your answers, full answers in writing. Thank you.
Okay, thank you.
We're trying to translate. Oh, lovely, thank you.
I will answer then. Thank you, Chairperson. I will try to be more concise in my responses according to the different questions that you all have asked. I should say regarding the sentences, we should remember that here there were sentences, criminal sentences. Those were issued, but against the civilians, against the assassins, hitmen, material authors. But those sentences were issued in the year 98, 2004, 2000, that is to say, they were sentences from several years ago. Currently, in a judicial sense, there are no criminal proceedings. There are none currently open. The decision against the military personnel from the Superior Military Court was from 1998, that is to say. That decision was issued 25 years ago. From 25 years ago to today, there has been no investigation against the military personnel. The demands for direct reparations, that is, for reparations, were all denied in the State Council, and no victims received reparations. The disciplinary actions that were those which could remove from their position public officials who violated the law. In this case, the members of the network of the Army were declared prescribed. That is to say that there were no sanctions on a criminal or disciplinary level against the military personnel. In all decisions, in all of them, of the different criminal judges who ruled against civilians in the decisions that were reached by the judges in the State Council and others, there have been thousands and thousands of exhibits, documents showing and demonstrating that the events did occur effectively and that there was a pattern. In fact, it was a network of made up of 41 networks who were operating throughout the country. That was 07. 01 was never investigated. 02, 03, 039, 040, they were never investigated. But there was a pattern. In effect, this is how intelligence forces worked against their targets. Information was reported to Bogota, and the orders were given to execute these people. There was progress with the unit for victims, but the victims unit was born nearly 20 years after the events. So I don't believe that any victim, but I'm not certain about this, has gone through the victims unit.
No tengo conocimiento para esa época.
I am not aware of that period. I did not follow up at a level on this case. I carried the case in the criminal jurisdiction. Now, regarding the issue of the statutory law, in effect, there was a statutory law. Currently, I am a congressperson. I am a member of Congress. And currently, I am speaking with the Ministry of Defense, with the National Directorate of Intelligence, with academics and experts, because I believe that we need to make changes on the intelligence law. Why? Because after the term effective of the law of intelligence, several cases have occurred of illegal activities conducted by military intelligence forces. Currently, there are proceedings in Colombia which are open in the public prosecutor's office against all directorates of intelligence of the military in various cases of illegal activities. Regarding my threats, I emphasize I left Barranca in 97 because I was going to be murdered. In 99, I published with Credus, my organization, the collective of attorneys with Credus, we published a book about this case. On the day when we released the book, my daughter was called in Bogota. She was a girl. They said, hey, say hi to your dad. We're calling you from the Army. Give us your address and tell your dad we're going to pay him a visit. And they left a message that they were calling me from the network, from the Army network. Obviously, up to this date, I have received several threats because of the cases that I brought against state agents who were compromised in many human rights violations, as well as threats made against members of Credus and other attorneys from the collective. And we have a case regarding that at an international level as well. Madam Chairperson, I believe with that, and in a very summary fashion, I believe that I have responded to all of the questions that were asked. Thank you very much.
Thank you for being so understanding in our difficulty with time. The presentation of the parties' arguments would now begin. The petitioners will have 15 minutes to present their arguments. Then the state will also have 15 minutes to present its arguments. Subsequently, if you, the petitioning party, so wishes, you shall have 5 minutes to exercise your right to reply. And then the state shall also have 5 minutes to exercise its right to a rejoinder. Finally, the Commission may ask questions of both parties. I now give the floor to the petitioners for their presentation of their arguments for 15 minutes.
Madam Chairperson, Commissioners, this case, as mentioned before, is about the operation between 1991 and 1993 of the Intelligence Network number 7 of the Navy. They operate in Barranca Bermeja, Department of Santander. It was not just illegal eavesdropping or surveillance, but a network of hired assassins operating under the coordination of the National Navy, the force in charge of river and maritime security in Colombia. This was a form of dirty war against the society, as Mr. Munoz said. The beginning of 1990s, or the 90s, there was a reorganization of intelligence activity in a model in which, paramilitary personnel, under direct orders from the General Staff of the Armed Forces, monitored individuals and followed these people, and they were target of attacks. Most of them died. 68 of them have been documented. The intelligence networks were created with an alleged counterinsurgency purpose under the influence of the national security doctrine and an expanded notion of internal enemy that has already been recognized by the Inter-American Court in the cases of Palacio de Justicia, Isaza Uribe, Pedro Movilla, Unión Patriótica. Thus, in 1991, through Order number 200-05, 41 secret networks were created at the national level in the armed forces, 30 from the Army, 7 in the Air Force, 4 in the Navy. In its written pleadings, the Colombian state stated that this was done within a legitimate framework of respect for human rights, and in order, the facts actually say otherwise. Under Permanent Directive 21 of 1991 and Circular 5315 of the same year, Network number 7 had a hierarchical structure under the responsibility and command of the Director of Intelligence of the Navy, along with military personnel, which operated clandestinely through front companies from where targets were all determined. Now, my colleague will talk about the crimes as part of this case and also the international liability of the Colombian state. Hello, everybody. All participants, my name is Alejandro Escobar Cortázar. I am a member of the group of attorneys José Alfredo Arrestedo Cajar. The network number 7 has been attributed at least 6 massacres, 17 extrajudicial executions, and 2 attacks against civilians. Added to the threats, homicides, attacks, persecution, and forced disappearances of collaborators, witnesses, and whistleblowers, executed as a strategy of self-extermination for impunity, as well as harassment, threats, and surveillance against representatives of the victims, as we heard before from the witness. The state pointed out in its written pleadings that the private agents with whom the Army network came into contact were mere informants. Therefore, their actions cannot be attributed to them. This representation considers that from the body of evidence, it is easy to conclude that the way in which these crimes were committed, their dimension, the social and personal conditions of the victims, and the absolute impunity that covers the perpetrators, show a powerful structure with ample operational and budgetary capabilities that could not have been carried out outside of the state. Thus, recently, the Truth Commission determined, based on judicial decisions, that the Army Network Number 7 functioned as a true death squad. More than 70 people were killed under the following modus operandi. 1. Hitmen on motorcycles shooting at their victims and fleeing, protected by power outages and the total absence of security forces. 2. Generally, no arrests were reordered or recorded, and only after a few weeks was a suspension of the investigation ordered. 3. Most of the victims were Ecopetrol workers affiliated to the Unión Sindical Obrera, USO, unionized transporters, journalists, peasant leaders, human rights defenders, or considered leftist political leaders. And finally, 4. After headquarters was discovered, the network moves to a new location, and in no case did the informants or collaborators have contact with the heads of the network or with members of the intelligence directorate, which of course facilitated the use of hitmen. Only the head of DINTE, the intelligence directorate, the head of the network, and the agent in charge knew the orders to assassinate the victims. Under this modus operandi, massacres were also carried out in the Billiards halls, El Tropezón, the Estadero 9 de Abril, the restaurant La Shannon, the Billiard Hall La Sede, Billiard Hall Versalles, and Bar El Estar. The magnitude of this violence and personal and political conditions of the victims plunged the civilian population of Barranquilla into deep anxiety and fear. Network number 7 of the National Navy was constituted as a true criminal apparatus with the objective of systematically and with impunity assassinating, among others, members of the political and social movement of Barranca Bermeja, considered as the internal enemy to fight, under the accusation of having links with the guerrilla Group National Liberation Army, ELN. Thus, the fact of this case involved violations of 1. The rights to life and integrity of persons extrajudicially executed or survivors of massacres or attacks, and the right to childhood of a murdered minor. The foregoing, inasmuch as the violations were ordered, planned, facilitated, executed, and covered up by state agents of the Intelligence Directorate and the public force, without measures being adopted with respect to a situation that was widely known and denounced. 2. The right to personal integrity of the victims' families, who suffered a profound psychological impact and suffered enormous pain and anguish as a result of the events and the resulting impunity. 3. The rights to freedom of thought and expression and of association with respect to persons who were executed because they belonged to organized sectors of the population, such as trade unions, social and political organizations, human rights organizations. Among the groups most affected were the Santander Transport Workers Union, Cinco Trainder, the Workers Union, USO, and the Regional Corporation for the Defense of Human Rights, CREDOS. We emphasize that the executions and attacks were motivated by intelligence information that equated social activism with guerrilla activity. Thus, the violations of the right to life are related to previous acts of stigmatization and finger-pointing. In addition, in view of their eminently political purpose, the violations of the rights of murdered trade unionists, journalists, human rights defenders had intimidating effects aimed at silencing dissident voices and instilling fear in the population. These actions and omissions engage the international responsibility of the state for being contrary to the general duties of respect and guarantee contained within Article 1.1 of the American Convention. Likewise, the internal regulations that supported the existence of Navy Network Number 7 are contrary to Article 2 of the Convention. Despite the fact that more than 30 years have passed since the events occurred, the Colombian state has still not implemented a legal framework for the control of intelligence and counterintelligence activities that protects the rights of civilians, particularly those who work in defense of rights or social and political activism. Next, we will refer to the violations resulting from the failure to investigate, prosecute, and punish all those responsible for the facts of this case, which to this day remain impugned. Thank you. Good afternoon, honorable commissioners, and the rest of participants and audience. My name is Sebastián Saavedra, attorney for the Colombian Commission of Jurists, CCJ. During the inter-American process, the parties have referred to the proceedings in ordinary criminal proceeding, military criminal proceeding, and disciplinary proceeding, also administrative litigation. I will now refer generally to these, adding a few brief comments in relation to the application of the principle of complementary. To analyze the ordinary criminal process, we must remember that the Inter-American Court has determined that the investigation of serious human rights violations must respond to the logic of the system in order to uncover the criminal network behind their commission. In addition, this must be assumed as a legal duty, developed with a due diligence and executed with a reasonable period of time. This has not been fulfilled and hasn't happened in the investigation of these facts in this case. Specifically, the ordinary courts handed down some convictions against some of those directly responsible. However, this took nearly 20 years from the occurrence of the first act, without the full attribution of responsibilities, especially of members of the security forces. Likewise, these convictions did not take into account the systematization of the facts by means of a case-by-case analysis and by concentrating only on the last links of the chain of the criminal network, as mentioned by the witness. Secondly, the military criminal justice system became a mechanism of impunity. In this regard, both the Inter-American Court and the Inter-American Commission have referred to the exceptional nature of military jurisdiction and its inability to investigate human rights violations. Likewise, they have established that there may be a fraudulent res judicata when a decision seeks to absolve the alleged perpetrators with a view to removing them from justice. In this case, as the witness stated, the military criminal justice system acted in such a way that the veil of impunity covered up those responsible from the very moment it became aware of the actions of Intelligence Network Number 7. Specifically, the decisions taken in 1994 and 1997 to close the investigations were made without taking into account the ample evidence against those investigations and made a short period of investigative activity. It should be added that this action was even allowed by civilian authorities when resolving the conflict of competences in favor of the military justice. Following this line, the acquittal through the military justice system prevented the ordinary courts from carrying out any investigation of the acquitted members of the security forces, thus creating a fraudulent res judicata. This was stated by the Regional Court of Cucuta on February 24, 1998, when it ruled that the military criminal justice system acted to favor those at the top of the intelligence network. For its part, the disciplinary investigation did attribute responsibility to members of the security forces, reaffirming that the decision of the military criminal justice system was deliberate in favor of those investigated. Despite this, the disciplinary sanctions was a severe reprimand, which does not reflect the seriousness of the violations. In addition, international standards added to this investigation affect this even most. The international standards have established that the appropriate scenario for clarifying serious human rights violations is the criminal investigation. Thus, the disciplinary process is absolutely insufficient. In view thereof, the state must be declared internationally responsible for the violation of Articles 8 and 25 of the American Convention to the detriment of the victims in this case. Lastly, Colombia argues that, by virtue of the principle of complementary, there should not be an analysis of the merits of the case, since the proceedings carried out by the domestic authorities would supposedly have established the corresponding responsibilities and compensated the victims. This argument ignores the reality of the internal proceedings by ignoring the cover-up and the fraudulent res judicata emanating from the military criminal justice systems, the lack of diligent investigation and the absence of reparations. In addition, with regard to the administration litigation, it is unaware of the systematic refusal of this jurisdiction to recognize state responsibility and consequent adoption of reparations. Therefore, the Commission must reject the state's arguments.
You could do it in your reply.
Sí, creo que tenemos 2.
I believe that we have 2 more minutes according to our records.
Thank you for being up to your time. Okay.
Gracias. Bueno.
Please.
Thank you. Well, thank you so much, Madam Chairperson. And we says David Mesa, I'm an attorney and a member of CCJ. And to conclude now, I will formulate my request, my petition, taking into account that more than 30 years have elapsed since the facts, and more than 19 years since the petition was lodged with the Commission, in accordance with the arguments set forth in the present hearing, as well as the inter-American proceedings. We request that the Colombian state be declared internationally responsible for the violation of the rights to life, personal integrity, freedom of thought and expression, freedom of association, and the rights of children, as well as judicial guarantees and judicial protection in relation to the obligation to respect and guarantee set forth in Article 1 of the Convention, as well as Article 2 in relation to the duty to adopt provisions of domestic law of the same international instrument. A prompt decision by the Honorable Commission is in view of the advanced age of the family members who have been waiting for years for justice, truth, and integral reparation. In this regard, we respectfully request that the Commission order comprehensive reparation measures in favor of the victims, including economic reparations, satisfaction, and non-repetition measures. Given the fact that none of the members of the armed forces have been sanctioned due to the closing of the process in the military criminal justice system, we request that the Colombian state be urged to file an appeal for review against in order to investigate and judge the serious human rights violations. For these events to not be repeated, we request that the Colombian state be urged to adapt the current intelligence and counterintelligence law in accordance with international standards regarding respect for human rights and adequate controls. Thus, it is necessary that the intelligence agencies have mechanisms that allow for scrutiny and independent administrative and judicial controls of the work that they carry out. For example, it is necessary that intelligence agents have judicial authorization to monitor the electromagnetic spectrum. Additionally, it is necessary to declassify the intelligence archives, declare human rights archives, be declared human rights archives, and hand over the information collected in the case of the National Navy network that was used to persecute, assassinate, disappear, and severely injure social leaders. Now I will be concluding. Finally, we request that the Colombian state be urged to eliminate the doctrine of the internal enemy, which perceives political opponents, alternative journalists, trade unionists, and any social activist as people associated with the guerrilla fighters. The Colombian armed forces continue to use these practices today to persecute and criminalize this population. Thank you very much.
Thank you very much. I now give the floor to the state's delegation for your submissions. Thank you. 15 minutes.
Gracias, señora.
Thank you, Madam Chairperson. Commissioners and the petitioner party, it is very important in that this opportunity to there is the Truth Commission, many peace agreements, which has been so significant for our history, to be aware of the truth and how the Commission for the Clarification of Truth in their document of findings and declarations speaks about the topic. It was established that at that time this intelligence network was based on the persecution of the guerrilla fighters through the armed forces, the police, and the intelligence agencies, which brought about severe crimes that were committed. In referring to the model of intelligence and violations of human rights, one of the cases to which the Commission for the Clarification of Truth makes special reference is precisely this network number 7 of intelligence of the Navy. There it is very crudely described how a powerful death squad operated with logistical elements trained to kill, that was responsible for dozens of killings and forced disappearances and massacres, the victims of which were primarily union members, politicians, community leaders, and activists. That is to say, the network of the Navy financed paramilitary groups with reserved expenditures. Unfortunately, these extrajudicial killings and other crimes and All of these situations that were described with the collaboration of members of the network of intelligence were committed, as was stated, between the years 1991 and 1993, events that should never have occurred. For this reason, this state representation wishes to express to the relatives of the 70 victims of the case bringing us here our most sincere solidarity and feelings with their suffering, not only the declarants, but also the delegates. Messrs. Delegates have made reference to the states in the ordinary justice system and criminal military justice system and the contentious administrative affairs system. I will try to be as specific as possible regarding this topic, as we have given quite a broad explanation in the criminal ordinary investigations. The Attorney General's office is assigned to Attorney General's Office number 92 to conduct this investigation against these human rights violations, being conducted immediately. The prosecutor's office processed these investigations, which was quite complex. In these investigations, several procedural ruptures occurred in order to individualize and identify the parties responsible for each one of the events that occurred. Thanks to these investigative efforts made by the investigations, various situations were identified in which 6 parties were found guilty. There is the criminal proceedings against Carlos Alberto, against the individuals named here, who via sentence on February 4th, 1998, the Regional Court of Cucuta found them guilty in the court of first instance against the individuals named here for the primary penalty of 30 years in prison and a fine as co-authors of the crime of homicide with terrorist purposes. In the following sense, according to the sentence, they were also found guilty with the additional penalties for a period of 10 years. Carlos Alberto was condemned and found guilty as co-author of homicide of 9 victims. This individual was condemned as the co-author responsible for the homicide of 32 victims. Both were
Ambos condenados recurrieron la sentencia condenatoria. ¿Sí está bien? Ah, perfecto.
The guilty sentence and on November 6, 1998, confirmed the ruling of the court of first instance. It was only the penalty that was modified against the following individual for 92 years and 4 months of prison, and the fine, given the importance of the testimony for the justice system. The declarant referred to this period, this lamentable period in our history, as what was called the justice without a face. Both prosecutors and judges, as well as the national court, it was not known who the judges were, which corresponds to the period known in our country as a period when the justice system was one of the systems most affected by that period in the criminal proceedings against Felipe Gomez and the following individuals named here. Via sentence on June 2nd, 2000, the second court in the circuit specialized condemned the people named. This individual was condemned to 20 years in prison for the following crimes named, and the individuals named here, Luis Felipe Gomez Lozano, was condemned to 30 years in prison as co-author responsible for the aggravated homicide and attempted homicide of 6 victims in events occurred on January 24th, 1992, in the following location. The following individuals were also condemned to prison for as co-author of aggravated homicide of 8 victims. Julio Ernesto Prada was condemned to 30 years in prison as co-author responsible for the aggravated homicides and attempted homicides of 15 victims. Likewise, the sentence was appealed The Superior Court of the District of Bucaramanga via sentence in June 2004, when the decision was confirmed. Finally, Oli Estela Osorio Reda presented an extraordinary resource of the Cassation Court of the Supreme Court of Justice, brought a cassation partially against this sentence from August 2005. The sentence was nullified, indicating that the right to a technical defense had been violated, indicating as well that regarding the additional rulings, other proceedings that were brought against the individuals, the Attorney General's office brought the case against this individual for the crimes of homicide, accepting the charges and expressing their willingness to accept the anticipated sentence. Following this, the court of Bucaramanga condemned to a primary case of 25 years and subsequent months for the crime of homicide with terroristic purposes, including the additional charges that were brought against the individual, charges being listed here.
Mr. Elena Robledo argued that despite the fact that he accepted the sentence, he did not accept the quantum of this punishment. On January 23, 2001, the Superior Court, the District of Bucaramanga, issued a sentence where they confirmed the lower court decision. They withheld. Now, the process against Ms. Osorio Ruedas, in October 2009, the Second Regional Court, Criminal Court, in Barranca Bermeja, convicted her and sentenced her to 4 years for aggravated homicide against her victim. Also, the legal process against Mr. Cáceres and Julio Ernesto Prada, a sentence dated November 11, 2010, the Third Court, Specialized Court, sentenced them to 3 years and months in prison because of participation in a criminal activity. Regarding the homicide of Ms. Munoz, the State Attorney General's office started the investigation, and in 1992 they issued a statement saying that they cannot process because the investigation led to believe that her death was a suicide. In relation to this military jurisdiction, which has been mentioned in detail today, the basic issue here is stated in the Article 221 of the Constitution, when there's this jurisdiction issue between the ordinary jurisdiction, the military jurisdiction. Back then, in 1998, the Superior Council, the Judiciary Superior Council, decided that all these facts had to be investigated by the military criminal justice. So at that time, they found that these were facts related to the military service. If we transport ourselves to 1998, a time when there was no clarity and transparency or certainty about who had the jurisdiction, having natural judge, who had to make these decisions. Unfortunately, this decision was made by the Superior Council, and it led to make it impossible to investigate and convict these members of the state. In the disciplinary investigation, or regarding that, I need to mention that investigation by the State Attorney General's office against 6 officers and under officers. This investigation is important because in the appeals court, they accepted this initial conviction. So at least there's a conviction with serious sanctions to the people involved or participating in the creation, financing, recruitment, and maintenance of higher assassins groups or death squads. Now, I have to recognize the words by all petitioners, where they mention that there isn't a principle of proportionality when the facts are so serious. There's no severe repression from the disciplinary justice. regarding the administrative proceedings against the state, there are contradictory sentences, several judicial decisions that recognize only a few or a reduced number of victims when we had such a large number of victims. I also want to talk, commissioners. I want to mention that this recount regarding the facts in this case is very important. Firstly, it is a reality that there's evidence about the willingness of the state to investigate these subjects, but I have to acknowledge that in many cases there wasn't enough willingness and commitment and compromise to justice to be able to finish properly all these cases. I need to mention the fact that the investigation had to be heard by the military criminal system. We were able to determine that there were state agents involved in these facts. So the findings of the judicial and the state attorney general's office and the state council, they all acknowledge that there was participation from members of the state through this so-called intelligence network number 7 of the Navy. In 2019, the National Judicial Defense of the state addressed the victims and proposed a solution, a friendly solution. Nowadays, facing a different situation, before you, with absolute respect, I want to reiterate this possibility to have some friendly settlement and solution. And finally, I want to mention that 6 of the victims recognized in this case have been recognized as well in the recent sentence issued by the Inter-American Court on Human Rights in the case of Colombia versus the members of the Unión Patriótica against Colombia. So it's crucial and fundamental to do this so that we can filter this information, we can clear this information to have a clear information about this representation. I have a question about the chairperson's participation. It's about the information of the victims who were repaired or received reparations, not as a product of a judicial order, a court order, but as an administrative proceeding. Information which will be submitted in writing eventually to all the commissioners. This is basically the summary of the state's participation, of the appearance of the state here, and I want to thank you all for this opportunity that had been granted to us to address you. Thank you very much.
Both parties do have the rights to a reply and a rejoinder. You were supposed to have 5 minutes, but we cannot afford that at all. So I'll give you 2.5 minutes. 2.5 minutes, and then you can submit whatever you wish in writing. I know, I said we have 5 minutes, but we because we have the commission has to ask questions. Yes. Yes. 2.5, please.
Madam Chairperson, thank you very much. We will address 3 of the elements submitted by the state representation. Most of the elements have been answered in writings in our pleadings. In regard to the victims in this case, which are being recognized in the sentence of Unión Patriótica, our position is that the Inter-American Court has a very specific position here. So this is an international finding. We have established that these victims granted authority to the organization to bring this before the Inter-American Commission on Human Rights. So in that regard, we agree with the argument of the state representative for the state. Second, regarding a possible settlement and friendly solution, we would have to consult with the victims However, we could probably say that we have presented our proposal for reparations that have been proposed in this case. So, through this commission, we would request the Colombian state that within the term established by this commission answer to these requests. We submit this to the Inter-American Commission, but eventually that will be also probably the content of a friendly settlement, which includes the acknowledgement before the international arena. That includes some of the expressions in the pleadings, for example, pointing out that the hired assassins were third parties, not state agents, as the Inter-American Court has found in similar cases like the Ranchera massacre against Colombia. We also want to clarify, as we mentioned before in this hearing, in our pleadings, that the military criminal jurisdiction is not impartial, is not independent, as this commission has mentioned, as the court has mentioned. And by 1997, the Constitutional Court had decided which were the jurisdiction rules. And in this case, the attribution to the military criminal justice was against the law. And as we mentioned here, the military court just had an appearance of justice, nothing else. It was just a mockery of justice to favor impunity. And so, before the appearance of prosecution, that has to be reviewed. That's one of our petitions. And finally, we want to tell the family members, we are going to communicate the expression of the state representative, solidarity with the victims, which is something very important for us. And to finish, there's certain reflection about the law of the victims, the law of the victims based on the principle of solidarity. So it's applicable in cases where there isn't a state responsibility or liability clearly established. So in a case where they are avoiding the responsibility by the state, the first step towards a settlement is acknowledging that responsibility. So the consequence shouldn't be applying the law of the victims, which has amounts based on solidarity. No, it's the application of the standards, at least the standards of the court against the state, based on the acknowledgement of liability. Thank you very much.
I now invite the state to make any submissions in rejoinder. 2.5 minutes. Thank you.
Thank you, Madam Chairperson. One fundamental issue that I believe is important to go into a bit is the issue of intelligence and counterintelligence in our states. That's a very deep topic that affects the right to privacy of human beings and their privacy rights versus, obviously, the interests of the state, both in investigating. And this is fundamental for regulations from the year 2013. We have a statutory law in our country that is to say a law with a higher range and of greater importance. This law was also reviewed previously by the Constitutional Court, and there was an important argument made regarding that issue with human rights, with regard to right to privacy rights and fundamental rights, which are consecrated in our Constitution. But in addition, regarding this law currently, as the declarant stated, it's important and necessary for the state as well to reflect on it again. And for that reason, in the year 2020, a bill was presented for a reform. This bill was to update these intelligence manuals to these constitutional principles. Unfortunately, this bill did not have a successful end, but there is a commitment by the state to once again conduct this exercise of review and present, hopefully in the next legislature, the modification or reform of this law 1621 of 2013, the issues of archives of information that citizens have knowledge by the commissioners of the state of Guatemala, which also had the opportunity to be aware of this. This is a fundamental importance for the people, the citizens, the respect of fundamental rights, and I believe that Colombia is overdue to do this task of declassifying this information and bringing about transparency in relation to these archives, which are currently there and which it is extremely important for true peace to exist, to obtain this information and make it public. I will conclude with this my participation. Thank you very much, Madam Chairperson.
Thank you very much. I now invite the members of the Commission and call on Commissioner Joel Hernandez, the country rapporteur for Colombia, to ask his question.
Gracias.
Thank you. I will be very brief because many of the questions have been answered. I will be very brief because many of the things that I wanted to ask have already been answered throughout the participations here. I just have one question for the representative and a comment for both parties. For the representative, this would be very helpful to me if we could develop more the allegations regarding the alleged violation of Article 2 of the American Convention, and to indicate for us what the reparation measures would be if the violation of Article 2 should be supported. My comment for both parties is to repeat the Commission's willingness to facilitate and a friendly agreement. It's very clear to us that the representation must bring this issue before the victims, and a process of dialogue must occur between both parties to reach an agreement, a friendly agreement. Having said this, we are at your disposal to make progress in this sense. Thank you.
Ask their questions and then you can answer. So I invite the second Vice President.
Thank you. Thank you, President Macaulay. And I know we're really out of time, so I appreciate your indulgence. I continue to be really concerned about the Military Criminal Tribunal and what seems to me to have been a participation. I think that you spoke about I'm not quite sure, the deliberate sort of avoidance of the compelling evidence that was before the Military Criminal Tribunal in finding no one accountable amongst the senior military officers. And I want to know, asking the petitioners, are you asking for anything in relation to accountability that would strengthen the accountability of those who acted on the Military Criminal Tribunals? Is that part of your request at all? And then for the state, I'm wondering, has any investigation taken place into how these military criminal tribunals were held from the point of view of, if appropriate, follow-up action or disciplinary action? Thank you.
Thank you. Commissioner Julissa.
Gracias.
Thank you, Madam Chairperson. Very specific questions. Firstly, I was going to ask that as well for the state. We are very interested by the issue of the relationship of the victims, which, if you could send that to us. And for the petitioners, two questions. One, in the case of Gloria Inesio, that you mentioned in the new part of the file, but there is no greater information. If you could send that to us. And also, I would like to specify, maybe perhaps later, the petitioner stated that the law of victims is based on the principle of solidarity. I remember this was said in the debate prior to the approval of the law, and the principle of solidarity was rejected because it was the right to reparations. This is the case that in Article 3 for victims, and everything implied by the law speaks about the right to reparations. So perhaps you are referring to an administrative reparation, not a judicial one, but I just wanted to specify that. Thank you. Yes, thank you, Chairperson. I have no more questions at this time. Thank you. Well, thank you very much, Chairperson. Perhaps to complement the written observations that will be presented. Firstly, regarding the state, it's our understanding that reference was, as the director made reference to various findings of the Truth Commission. What legal effects would be had in this sense? Are the events recognized, the effects thereof of this proceeding, with the corresponding judicial effects, and what is the position on the state regarding that? The second one has to do with the reference that Article 221 of the Political Constitution of Colombia. It's our understanding that it was expressed that there was an interpretation that favored the period at the time of the events. They were tried in the military system. We are understanding that a violation of Article 2 was not referred to, or for this point, it's believed that the regulations as such do not have problems with the conventionality for any interpretation, or if there were any, could you go into depth on that matter? And thirdly, has to do with the request that was made by the petitioners, and the question is for them regarding updating the law of intelligence and counterintelligence. Specifically, what would be, if applicable, the specific measures to be taken? Thank you very much, Madam Chairperson.
Thank you. Thank you so much. I will not detain you by asking any questions. I rely on what has been asked. I think we will ask you to put your answers in writing, if you would, because I am not sure that you could answer any of these questions in less than a minute each. So, and we would like fulsome answers to the questions from both parties. So if you could, so I would just like to say, because of the shortness of time, we have to end this hearing of this case here today, and look forward to receiving your answers from you on the latter questions which were asked. I would like to thank the delegation of the illustrious state of Colombia and the ambassador for his appearance here, and distinguished representatives on behalf of the petitioners for your fulsome participation. I must just remind you that you have 30 days from today to submit your written observations, and I'm sure we will get that from you. And with that, I close this hearing and thank everyone who is here present, because supporting the hearings is very important to the system of the inter-American justice of human rights. Thank you so much. Thank you so much.
Thank you. Thank you. Very hard.
Testing, this is the English booth. Testing, testing, the English booth. Testing, testing. Thank you. Yeah, perfect.
Good afternoon, everyone. We are very thrilled to see this room filled with so many young people and middling and whoever, old like me, and so on. It is very good for all of us, all in all stages of life, to be here today. And this is such a very important issue, which the Commission deals with avidly and with great concern. So good afternoon, everyone. I open our hearing number 6 of the 186th session of the Inter-American Commission of Human Rights, entitled Situation of Human Mobility from an Ethnic Racial Approach, which was requested by the Promise Institute of Human Rights at the University of California, Los Angeles, and Racismo MX, and the Center for Immigration Law and Policy at the University of California, Los Angeles, the Center for Justice and International Law, Sahil, the Observatory on Racism in Mexico and Central America, composed of a whole heap of Spanish. Excuse me, I will skip that. And I hope when you speak, and if you belong to those groups from Mexico and El Salvador and all the Spanish-speaking countries, please identify yourself and indicate what language you will be presenting in. And in conjunction, all of the Spanish persons, in conjunction with comunidades indigenous. Do you see my problem? Once I see Spanish words, I get confused. Anyway, there are a lot more. And the Center No, the Migrant Workers Alliance for Change, and that's MWAC, and Center for Gender and Refugee Studies, CGRS, and National Immigration Project of the National Lawyers Guild, NIPNLG. My name now, I mustn't miss that one. My name is Margaret May Macaulay. I am newly the president from last night of the Inter-American Commission of Human Rights. I am accompanied by my second vice president, my sister commissioner Roberta Clark, also newly from last night, and my brother commissioner, favorite person, Joel Hernandez, and our special rapporteur on economic, social, cultural, and environmental rights. And the executive secretary, Tanya Renaud, and Maria Claudia Polido, vice executive secretary. So we're very happy to be here today. And I begin with a very, very warm greetings to you all, and civil society especially, who will be presenting to us today. Let me just explain the distribution of time, because we're all controlled by the strictures of time. Civil society, you will have 47 minutes, which is very long in the sense of our hearings, very long. You'll say a lot in that time. And then we, the commission, can then pose questions and make comments for 25 minutes. And then we close. And I am supposed to take 3 minutes, but I might take half a minute more. So, thank you all, everyone. I give the floor to civil society.
شقيقي بيني ونوخك ليشكوال بخون قيخ بكما شقاري قد بلسيخ ينكي ياري قيختين قد أشغبون قلخوخ تقتيخ قد أشغبون في قد أبلشين قد بيخبون جيبات كاري قشاخ ريوي نقيري شقيري أتشقائري أقوالا تقي ألف باكيتي نميت كو خلخوخ تقريك أيوال إكامي بيتخون أبون إكين باكاشلان سيخ. Buenas tardes.
Good afternoon, commissioners and everybody present in this hall. My name is Silvia Raquec. Along with my colleagues who represent multiple organizations, human rights organizations, we want to thank you for the opportunity to bring to you and present to you in a thematic audience the impact of racism, human mobility, and immigration in our region. The purpose for this hearing is to show how racism affects the people in movement throughout the whole journey, including enforced movement, the criminalization in the borders, and we hope we can show you why an anti-racist approach is crucial to avoid this violation of human rights for immigrants. We will share with you the history of the journey of several people who will describe how the racism affects people moving in the Americas. These stories identify the racism against Black and Afro descendants in the Tapón de Darién, the lack of resources, and the police violence against the people who are now residing in Tijuana, the militarization against Black and Afro descendants in the southern border in Mexico, the racist criminalization of the southern border of the United States, and also the linguistic violence and suppression of identification that indigenous people suffer. We will conclude with recommendations to the Honorable Commission to have a focus on against racism involving mobility in the Americas. Marisol Aguilar from Racismo MX will talk about the origin of racism in Latin America and the impact on people who are moving. Good afternoon, commissioners. Racism in Latin America has a specific date where it started, October 12, 1942. And 1492. And this is because most of the Latin American states don't mention racism in the regulations, policies. And this results in the racial mixing and discrimination suffered by people in this context. When we talk about mixed races in Latin America, we have to talk about how different colonial rules operated. First, separating races in society. Now, that doesn't exist. Countries like in South America and Caribbean area. And the second, they forced people to adopt the European way of life and culture, displacing them and robbing them of their original culture. This was really an imposition. It was not translated into an equal judgment of rights. This is something that several states in Latin America have used, where supposedly there's a biological and cultural mixture of European and indigenous peoples, but erasing other identities different from those European. Now, this race mixing, it's really an ideological project that attempted to unify the people to have a common identity without offering any real equity conditions. However, this narrative created that those people who didn't belong to that were marginated and were rejected. This also affects the mixed races among black people, except for certain exceptional cases. The descendants of Afro-Americans were not included as part of that. That's the case in Mexico. In 2019, they recognized for the first time their existence in Mexico. There's racism against black and indigenous people as inferior genetically and dangerous. This is still current because of the rules that allow the states to follow these people based on simple appearance. In this regard, we highlight the case of Amparo de Revisión in Mexico. In that case, the Mexican Institute of Immigration detained and tortured 3 people in Chiapas because they didn't look like Mexicans, they said. That's the first time the Mexican state recognizes racial profiling against people, and that showed the lack of constitutionality of Articles 97 and 98 of the immigration law that granted powers to immigration agents to detain or monitor migrants. Racialization is the process by which the physical or cultural characteristics of a person are read and narratives are attributed to them, generally negative stereotypes being those assigned to people with brown indigenous skin. So it is important to highlight that because of this, racism is not only it's also not only against black, but also mestizo.
También
In fact, in our report, we emphasize the fact that migrants of Caribbean descent, although they are not identified as people of African descent due to their accent and other racialized markers, in other words, an accent that is associated with what is European is not a motive for detention, while other racialized languages are such. Therefore, we can affirm that migration is racialized. We consider that it is necessary to look at the ethnic racial identity of people in the context of mobility for 2 main reasons. The first is that indigenous persons of African descent and racialized people are immersed in contexts of historical and structural inequality, living in poverty, with greater vulnerability to violence and the effects of climate change, and because of these conditions, they are the ones who normally move on in an irregular manner. The second reason is that the authorities of Latin American countries of transit or destination discriminate against and violate the rights of racialized migrants because they do not fit the mold of the idea of the national person, and consequently are victims of institutional racism. Thank you very much.
presenting our speakers today. Building on the analysis provided by Racismo MX, our next speakers, John Lazar, Geraldine Joseph, and Eric Crew with the Haitian Bridge Alliance, will discuss anti-Black racism in the context of migration in the Americas.
Buenas tardes a todos.
Good afternoon, everyone, especially the commissioners. I'm going to present this in Spanish. I am a survivor of the Haitian earthquake in 2010, which killed more than 250,000 people. I almost lost everything in the earthquake. I lost my brother as well in the earthquake. For that reason, I had to leave Haiti and go to Brazil, where I spent 2 years before racism forced me to leave again. In total, I crossed through 10 countries to reach the United States. As a Black migrant, racism and discrimination affect me and other Black migrants in all parts of the world. In Brazil, there is a labor crisis mixed with racism, discrimination. Many Brazilians have begun to kill by gunfire Haitians. Sometimes they stab Haitians or say that the Black people took Brazilian jobs. That's why most Haitians left Brazil. Women cannot work. They discriminate against women. In the area where I was, I made some complaints. That's why I was threatened, and they tried to kill me, because Black people did not have rights, not even at job. They cannot complain about issues with receiving payment, and go to the police, and they won't give you just cause. They fire you without giving you anything, even if you have been working for 4 years, 6 years with them. In October of 2015, a Haitian migrant was murdered. On September 13th, 2018, another was killed, Polimuzilis. In August 2015, a group of Brazilians killed another Haitian, and 5 were severely wounded. Before they killed them, the group of Brazilians accused them this way. They're the people who came to take away Brazilian jobs. The press published the news when it occurred. From Brazil to Peru, Ecuador, Colombia, Panama, Black people are suffering terribly in every place they go to. Racism, discrimination, abuse. There is a Black migrant who was raped by armed thieves when she was raped by thieves. There was a time when many Haitians died at sea, died crossing through Nicaraguan territory because they did not want Black people to cross through their national territory. They used electricity to prevent Black migrants from crossing through, which killed them. Women have continued to be raped. It's with great sadness that we say many women are subjected to these acts. As human beings, they are kidnapped, raped, beaten. They break their legs, and many women are abused. Men abuse them in front of their husbands, and their husbands can do nothing about it. Some of these husbands have to sacrifice their lives to defend their wives from this terrible action, and they are shot with pistols. They take their telephone, their money, and they break their arms. When a woman has to face this sort of situation, it's a severe violation in both senses of the word. This person ends up living with a scar of trauma. Many Black men are also violated, raped, and treated like women. one of the women who were victims.
Read a testimony from a woman who was abused. When I left Colombia, they started attacking. I started to try to get through the forest the first day. Despite the difficulties on the road, it was really hard. Someone took me behind a rock and raped me. I was crying. He told me he preferred to kick me. He pulled out a gun on me. Even though I was crying, I managed to run and get away from under a bush. Then when I was in pain, until I got to Mexico. Even when I got to Mexico, I couldn't walk. I was in pain. Because they beat me so long and they raped me. They made me perform oral sex. And I got a lot of pimples in my mouth. I couldn't speak well. I couldn't eat well. It was a great pain for me. I went to the hospital and I couldn't explain what happened to me. What I had to do, what I had to flee. It wasn't just me, it was a lot of people.
La segunda persona es
The second person is a man who explains the following. The worst part is when I see the robbers who took my wife to rape her. When I protested, I complained, one of these individuals pulled out his gun and shot me in the wrist. I screamed because I didn't want them to do this to my wife, but they left with her. My baby was crying for her mother. We had a baby then. When I noticed that the bone in my arm was broken, I was suffering in pain. And there was another individual, and I told him, I have a broken hand. There are several men raping my wife. So this gives me leaves me with a very bad aftertaste. He said, to witness how they rape my wife in front of me, and you cannot say anything because they are the ones who are going to hurt my wife. So you're being confronted in two ways. I don't have the heart to explain the whole thing in detail. It's very sad, and the tears come to my eyes. But I was put in contact with Haitian Alliance in Tijuana. They helped me with feeding my family and medical attention. But all the sexual violations and all the results were negative after so many violations. Now they take the money. Many of these robbers beat up the men, rape women after taking all their belongings. Once they reach Mexico, the problem is even harder. They're not being treated. Some people have to sleep on the streets. They don't have housing. They don't have a house. They suffer discrimination, many times abandoned among other blacks in the streets. Sometimes they're being shot. The bodies are just covered with a sheet. Nobody can approach and ask for information. Nobody will tell you anything about what happened because this is a black migrant. All throughout Mexico, people are sleeping on the streets. They don't have a place to bathe, for the basic needs. They don't have bathroom. If they want to take a shower, they have to pay for it. Pregnant women sleeping on the street, on the sidewalk, almost about to give birth. They don't have any means, financial means, or medical attention. Sometimes they are given some medications that actually will induce hemorrhages. The government should actually implement a system for migrants when they come to the country so that they can have some medical attention. They have temporary housing and being welcomed with psychological assistance. The government has to guarantee also a safety system for all black migrants. They need to know what their rights are and acknowledge their rights as humans. When they come to the national territory in Mexico, a lot of black immigrants are being shot, are being stabbed at home. And the worst part is there's no justice for black people in Mexico. There are a lot of people who suffer mistreatment by uniformed police officers. They are threatened, they're robbed, sometimes they're kidnapped. They make them call their family to demand money. I personally have been working for 5 years with the Haitian community that is subject of so much racism and discrimination for Mexicans. And this is the service I lend to my community. That's the work I was doing with Haitian Alliance. So I stopped my car, took my money. I'm taking phone calls from unknown people, text messages. People look for me. They're threatening me. They want to kill me. Despite all this, we left that area to see if we can be left alone, but they keep looking after us. We're going to spend 10 days in a house. We're going to be hiding, and this is all the abuse that we have faced. Thank you.
English briefly. I'd just like to point out that Mr. Lazar gave his testimony here today not in his primary language, Haitian Creole, but because simultaneous translation services could not be offered, he presented in one of the language that he had to learn in order to survive his migration through the Americas. And this is reflective of an additional barrier and layer of discrimination that Haitian people face when trying to access their rights in the Americas. Now, the discrimination, violence, and extortion that Haitians and other Black people experience while in human mobility throughout the Americas is an ongoing human rights violations with historical roots. It is animated by anti-Black racism, an anti-Black racism that motivated the earliest immigration policies and continue to shape immigration laws through the present. In fact, states in the Americas are stepping up their collaboration on sea interdiction, militarized borders, mass detentions, mass expulsions, mass deportations, all in the name of prevention through deterrence or to control flow of Black people who are just exercising their right to human mobility, their right to seek refuge, their human rights. Now, Haitians have been one of the most common targets of states' racist exclusionary policies, but they're not the only, with Cameroonians especially suffering similar targeting, and issues also are affecting indigenous people in migration. So we are calling for a coordinated anti-racist approach from states and non-state actors to address the harms that Haitians and other Black people experience while migrating through the Americas. That means structural reforms in inter-American relations and repair for ongoing legacies of colonialism, slavery, and neo-colonial imperialism. That means states immediately offering increased protections to Black people in human mobility. So with the dire conditions that they're facing, protection delayed is protection denied.
La próxima ponente es Jessie.
The next presenter will present regarding the racism faced by Black and African descent migrants in Tijuana, regarding access to health services, linguistic support, as well as police violence. My name is Jessie Valse. I am a Haitian woman. I am originally from Haiti. I am a community organizer at Espacio Migrante, a civil organization located in Tijuana. From 2016, a growing number of Black migrant people, especially Haitian people, have reached Mexico. After a dangerous travel through Central America and South America, I hope to reach the northern border of Mexico and request asylum in the United States. However, many people end up stuck indefinitely in Mexico. And this number has been increasing. In 2015, my mother reached Mexico City. However, due to discrimination and the lack of work and not speaking, because she didn't speak Spanish, she decided to come to Tijuana, but she was detained at the airport by authorities of the National Immigration Institution without an interpreter. She was detained at an immigration facility, and with what little Spanish she spoke, she was able to read on a sign that it said she had the right to request asylum in Mexico. The migration guards, noting that many people had taken that information down, decided to take the sign down. As a retribution, they tried to convince my mother to sign her voluntary return. After 3 months in detention, she requested reunification, and thanks to her, I am here with my sister Camille, my twin sister Jessica. Currently in Haiti. Haiti is the largest source of asylum applicants in Mexico and has one of the largest flows of migrants in the Western Hemisphere. In 2021, 13,606 Haitian citizens presented themselves to the immigration authorities due to institutional racism that black people face in Mexico, the lack of immigration documents, the tendency toward militarization, and the lack of interpreters and translator in institutions. Black people face a systematic denial of their basic rights, such as health, education, residency, in addition to other violations of their human rights by the authorities, such as the police, immigration, the National Guard, and the military. In Tijuana, the Haitian and African population is not given access to health in a systematic fashion, especially because they are black people, in addition to the fact that they don't speak Spanish, and not having access to health during a pandemic can be a matter of life or death. This was the case of Umar Faruco, a young person from Ghana who was in the process of family reunification to bring his wife and children to Tijuana. In 2021, he developed a respiratory illness. However, in the hospital, in the public hospital, he was denied access, and he died outside of the hospital as a result. Hundreds of Haitian women who are pregnant do not receive medical attention because they do not speak Spanish. In October 2022, a Haitian woman, resident of the shelter, went to a public clinic in Tijuana, because she had a great deal of pain, but they would not allow her to enter. She was only allowed to enter when she was joined by the coordinator of the shelter. However, she was warned that she would not be given attention if she did not bring an interpreter. The doctor who dealt with her was openly racist toward her, saying, "Haitians come here to take advantage. They're not like the Ukrainians who do need to come. Haitian women cause a lot of problems. That's why we should tie them up when they're giving birth. We have to tie them up because they move too much." Weeks later, another Haitian woman gave birth on the streets because she was not received by any public clinic. These are three of the many cases of lack of access to health services for women who are in a situation of mobility, police violence, as well as a practice that has cost lives. Police use racial profiling to identify black migrants and detain them. The police takes away their documents and intimidates them. In January of 2020, a Haitian man suffered an asthma attack while he was interacting with a municipal police officer in Tijuana. He asked for help, but he was beaten, and that ended his life. The authorities have refused to publish his name or take responsibility for his death in shelters. We are witnesses of these abuses every week, and used by the authorities against the Afro-descendant or black population. Haitians in Mexico are also made up of many families with children of a school age. However, they are systematically denied the right to education for black children. The lack of documentation and not speaking Spanish. The audio has cut. The interpreter cannot interpret. These are the causes for the school authorities to deny them access to school. An Afro-Honduran woman told us that when she tried to sign her child up for school, the educational person asked her, "But what is he, Haitian? Because we don't receive Haitians here, because we only speak Spanish here." That's an example of the racial discrimination against black and African descent children throughout national territory. Black people or African descent people are not allowed to have the right to free transit, even if they do have immigration documentation, which gives them this right. Haitian and African people who travel from Tapachula to Tijuana have been detained and interrogated at checkpoints. This is racial profiling. In many cases, they are forced to get off the buses and they are locked up in immigration stations without interpreters, without being informed of the reason. This was the case of a woman from Tongo who was detained in Mexicali at a checkpoint in Baja California in June 2022. In addition, immigration agents asked for money from all of the African people who were detained in exchange for being set free. As they did not have $700 that the immigration agents were asking them for, she was returned to the south of Mexico, to the state of Tabasco, without her document, money, or belongings, after an agent of immigration signed the official document for removal. We must bring an end to such discrimination and racism against African and Afro-descent people in Mexico.
Legal Director of the Black Alliance for Just Immigration, and their client, Rabbi Kabamba da Silva Felipe, who will discuss racist state violence in the context of militarization, criminalization, and the suppression of protests by Black migrants at Mexico's southern border.
In recent years, the United States and Mexico have been working together to prevent people in migration through the Americas, particularly Black migrants, from reaching the U.S. border and seeking asylum. These efforts to externalize the U.S. border have taken different forms, many of which have been brought to the Commission in previous hearings, including the Remain in Mexico program, Title 42, and U.S. laws that criminalize border crossing. Just over a week ago, the Biden administration announced a new asylum ban that will prevent thousands of migrants arriving at the U.S.-Mexico border from exercising their international right to claim asylum. Increasingly, and as we will outline further in our written submission to the Commission, the U.S. and other countries in the region are using harmful and unregulated digital technologies to enforce borders, obtain information from migrants seeking asylum or humanitarian assistance, and further monitor and surveil them. All these border externalization, deterrence, and enforcement measures disproportionately impact Black migrants and fuel anti-Black racism throughout the region. As affirmed by the testimony you will hear today, in both Mexico and the United States, Black migrants, like all Black people, are frequent targets of racial profiling, police violence, and over-criminalization. I will now pass the floor to one of Baji's clients, Rabbi Kabamba da Silva Felipe, to share some of his migration story and the human rights violations he experienced with you. Rabbi will present in English as he is unable to present in Portuguese due to the lack of simultaneous interpretation in his native language today.
After my family was forced to leave Angola, our journey through Latin America was shaped by racial discrimination and abuse. My testimony today will highlight the many months that we were stuck in Tapachula, Mexico in 2019. This is where we experienced some of the most significant anti-Black violence and persecution. I will also briefly describe the racist treatment I experienced in immigration detention after arriving in the U.S. to seek asylum. My family and I were forced to leave Angola because our lives were in imminent dangers. So my father, sister, and I flew through Brazil and Ecuador. We then began our overland journey, hoping to reach Maine, where my mother and sister were living. The Darien Gap was the most dangerous and difficult part of our journey, as I lost my father during this part of our journey. Before we exited the Darien Gap, we saw others die and being killed, face threat at gunpoint, and taken captive and robbed. We were very afraid at various points along the journey in South America. My sister and I fell sick despite the horrific obstacles we faced. We eventually made it out of the Darien Gap to Panama and continued through Central America. In May 2019, we crossed the river from Guatemala into Mexico. Near Tapachula, we were stopped by Mexican immigration official and taken to the immigration detention facility called Ciclo 21. At the time, Mexican officials had stopped giving people exit visas that allowed them to continue north to the U.S. border. Instead, they started detaining people. We camped outside of the Ciclo 21 in the street along with hundreds of other Africans and Asians who were stuck in Tapachula. We had no sanitary items or place to shower. We had to use the surrounding rivers to bathe and drink water. We could not get jobs or access basic care. We were watched by National Guards who said this was their country and we might die here. As more black migrants were getting stuck in Tapachula, I started to witness and experience blatant anti-black racism and violence. One evening, another Angolan man was attacked by Mexican police who pointed a gun at him and choked him with a baton. They beat him, took all his possessions, and left him in the forest. When he returned beaten and bloody, we discovered that he had internal bleeding and could not walk for days. After seeing the abuse, the violence inflicted on black people, we did not feel safe in Mexico. We left home for a better future, but here we had less safety access than basic needs that we did have in our own countries. Eventually, we organized ourselves into assembly of African migrants to protest treatment. We demanded the Mexican government provide us basic needs and treat us equally. Instead, they brought in the police and National Guard who sprayed tear gas and threatened to shoot us. We stayed together, and together we were strong. We spent months protesting, and finally in late 2019, the Mexican government began issuing visas, exit visas to some of us, but they were targeting the leaders of the protest, including me, and wouldn't let us leave. When I went to the immigration office to get my visa, the officer came out and said that guy will stay here and die here. We will kill him. They never issued me a visa. Eventually, I had to shave my head so that I would not be recognized. This way, I was able to leave Tapachula and travel to the Ciudad Acuña, near the Texas border, and cross into the U.S. Once in Texas, we encountered a Border Patrol agent and requested asylum. We were immediately detained. We were treated terribly in immigration detention. It felt like a prison. People threatened we were going to kill some black monkeys, and the guards were laughing. The racism continued. When I felt sick in the detention, they told me, wait until your day comes. But finally, after arriving before the immigration court twice on my asylum claim, I was released on a bond and took a flight to Maine, and finally reunited with my family. Thank you.
Our next speakers are Isaac Selwyn of the Immigrants' Rights Policy Clinic, part of UCLA Center for Immigration Law and Policy, and Dixie Gallardo Aldana, a client at UCLA's Immigrant Family Legal Clinic. They will be discussing the criminalization of migration at the U.S. southern border, including the racist history and current impacts of the U.S. illegal entry and re-entry laws.
Thank you. Honorable Commissioners, the borders of the United States are governed by laws and policies that are rooted in racism, causing profound harm to black, brown, and indigenous migrants in the Americas. Some of these have recently received significant attention. Among them, the Biden administration's proposed rule that will block access to asylum for most people in transit. These laws are nothing new. The US has long used its borders as a tool of racialized violence, to ethnically cleanse indigenous people, to uphold slavery, and, as is our focus today, to criminalize the movement of Latino people, especially those coming from Mexico. In 1929, the US made crossing its borders without permission a criminal offense. This criminalization of migration had explicitly racist motives. Congress passed this law following testimony from a eugenicist that, quote, immigration control is the greatest instrument which the federal government can use in promoting race conservation of the nation. The laws criminalizing entry and re-entry to the United States are still in effect, codified at 8 U.S. Code sections 1325 and 1326. These are currently the most prosecuted federal crimes in the United States. Tens of thousands of migrants are prosecuted under these laws every year. 96% of those criminalized under illegal re-entry are Latino. These numbers make clear that the racist intent of the laws is still playing out in practice. But the US is not reckoning with addressing these and other laws relating to migration through an anti-racist lens. A regional approach is needed, informed by the rights to family, equality before the law, and due process, among others enshrined in the American Declaration. Consider how the US has failed to respect these rights, as you hear from Dixie Gallardo Aldana, who is one of the many people prosecuted under these racist laws and separated from her child at the border as a result. Dixie, gracias por estar aquí con nosotros hoy.
Dixie, thank you for being with us today. I am from Guatemala. In 2017, I came into the United States. I repeat, in 2017, I entered once again the United States with my son, Roberto, 11 years old back then, seeking protection from domestic violence. When we got there, we were separated. I was asking, how come you cannot have me along with my son? And other mothers had their children with them. Hours later, they told me to gather my son's clothes and to put them in a separate bag. Hours later, they came with my son, Roberto, to tell me to say goodbye, that I was never ever again going to see him. I remember Roberto was just hugging me. There was a long line of children. He was just saying, "Mom, be strong." And I would tell him, would scream and say, "Please, talk to my brother, find my brother, talk to him." After that, I was shackled and I was handcuffed. I was transported to the federal court to be sentenced and convicted for re-entering the country. There were many parents with 3-month sentences. Mine was 2 weeks. Then I was taken to the federal jail, where I lived through the worst 2 weeks of my life with high blood pressure, hemorrhage, and a very strong and affecting cough. Then I was taken back to the icebox because I thought I was going to be back. It was promised to me that I was going to be back to see my son, and that was not true. I just saw a mother losing her daughter, not being able to say goodbye. Then I was transferred to Arizona. I wanted to be heard that I was a victim of domestic violence and I had the right to be heard. But they would say, "No, you're going to go back to Guatemala." After that, I had a hearing. I had the worst possible judge. I was in custody for over a year. For 2 months, he didn't want to grant me a bail for having re-entered the country. Almost 2 years later, in detention, I was given a bail by a separate judge, and I was reunified with Roberto. To this day, there are multiple schools. This really impacted our lives. I wouldn't wish this on any other mother. Thank you.
Las próximas ponentes son Alba González y Odilia Romero, de Comunidades Indígenas en Liderazgo, o CIELO, que van a identificar el racismo que enfrentan personas indígenas en el contexto de movilidad humana, destacando la violencia lingüística y la separación familiar.
Alba González, they will be talking about the suffering in the separation. Good afternoon. My name is Alba González Velázquez. I am a Maya Quiche Spanish interpreter from Cielo, where we fight against racism and linguistic violence against immigrants. Since I was born, I have suffered racism. I left Guatemala when I was 19 years old. I crossed from Reynosa, Mexico, to Texas. We had already escaped from immigration authorities, but they sent the dogs. They said, "Hands up." We were taken to the icebox, those very cold rooms where no windows, no sunlight. We were all minors. Our feet were wet. From the icebox, we were watching the officials and officers doing paperwork while they drank from their big Starbucks cups. In the meantime, we were freezing to death and not eating because they gave us bread with frozen ham, and we were not used to eating that. Many children were crying. It was really traumatic to see and feel when children were being separated from their grandparents, mothers, or loved ones. When I told them that I was 19 years old, they put me in a truck with other migrants. I was the only woman. The men had their hands and feet shackled. I arrived to the detention center. I was fingerprinted and put in another cooler. They gave me prison clothes, navy blue. And I was kept in a room with other women, with 40 women, in double beds. When I woke up, I would be scared because it seemed like we were in a lonely cemetery. I was locked up with women who spoke different Mayan languages. They spoke Mam, Quiche, and other languages. Many of us did not understand a single word because they didn't give us an interpreter. At 5 o'clock in the morning, we would have cold milk and frozen food for breakfast. That made me sick. If we wanted to eat fruit, we had to work 3 hours for $1 to be able to buy it. We were also harassed. When they gave us the forms to ask for asylum, they were in English. We didn't understand anything. We couldn't fill them out. They never told us we had the right to a lawyer. When I had my first hearing, I didn't have an interpreter. I didn't understand anything the judge said. Now that I work in the courts as an interpreter, I think it was my preliminary hearing, but I don't know. So I learned that the sponsor is the person in charge of a migrant. But migrants don't need a sponsor. We don't need a sponsor because we work to support each other, our families, and to support this country. After 8 years of my confinement, I performed with minors in El Paso, Texas, near the place where I was detained. It hurt to see the children. That brought back the same images because many things have not changed. But this made me stronger, which is why I decided to become an interpreter, to guarantee the right to interpretation to those individuals who migrate. I have seen things like this in San Diego, Colorado, El Paso, and other places. Why do they make us live through this? Why do they make us go hungry? These are policies aimed at killing us in multiple ways. They can't do this to us just because we cross the border. This is inhumane. This is racism. Thank you. "42 years ago, my story was similar to that of Alba's. I was 10 years old when I moved. The person who helped me cross the border spoke my language. That was crucial to unify me with my parents. Reunification and family separation is nothing new among indigenous communities. In the last 42 years, the criminalization of migrants and the dispossession of territories has increased. In Oaxaca, more than 400 mining licenses have been granted to foreign companies in indigenous territories. The same happens in the Quechig, Lenca, Miskito, and other lands. At this moment, transnationals and capital are after the natural resources of indigenous peoples. But the capital also needs cheap labor, and we indigenous people work here in construction, restaurants, gardening, care and agriculture, and this has generated dynamics of modern slavery, in fact. This week, a New York Times report states that the number of unaccompanied minors from Central America has tripled. Our work has made us understand that these children are making an effort to go to school and to work while they are caught between the politics of sponsorship. They have to pay debts to their coyote, bail bonds, support themselves and their families, and pay other bills. What this piece of news doesn't say is these are indigenous children. But we can see the correlation between indigenous children, dispossession, exploitation, and death, such as the femicide of a young girl, Reina Ical, who was fleeing from criminal networks that dispossessed them of their land in the municipality of Carcha in Guatemala. I was a monolingual child, and like me, there are thousands and thousands of children. The number of children separated from their families and lost in shelters and detention centers is still unknown. One of the reasons that prevent reunification is that the language spoken by the children is not considered. At Cielo, we have worked in family reunification processes through interpretation in several stages of the legal process. In 2022 alone, we handled 3,060 cases in 23 of the 52 states in the United States. In all these years, we have come to one conclusion. Latinity is a killer of the struggles of the indigenous communities because several organizations inserted in the movement for the defense of migrants do not consider interpretation as a right, and they homogenize us as Latinos, and they impose the Spanish language. Part of this data can be found in a report, Situation of Criminalization, Racism, and Linguistic Violence Against Displaced Indigenous Communities, which Cielo will present before this commission.
The
last presenter is Silvia, who will present the recommendations of our delegation with regard to the need for an anti-racist approach toward human mobility in the region. In conclusion, the experience of mobility in the region is a racialized experience where states, as we have heard, where states do not have an anti-racist approach to the construction and generation of their policies, which directly impacts the daily experiences of forcibly displaced persons, migrants or refugees. States have likewise failed to address the general situation of unaccompanied monolingual children, a situation that is accentuated by the level of linguistic and police violence against indigenous people and those of African descent in a situation of human mobility. Therefore, in order for there to be an anti-racist vision in the migration response to human mobility, it is necessary for all public policies to justify with an intersectional analysis the structural and systemic factors of oppression that exist and how they operate among each other, how as barriers to access to multiple human rights, not only those related to mobility, such as nationality, condition, or legal status, but also economic, social, cultural, and environmental rights. In addition, during the construction of public policies, as a mandatory and unavoidable requirement, a space must be opened for participation in which individuality and the diverse identities of mobility and racialization are heard and recognized, in order to guarantee an adequate design and implementation of public policies that seek equitable access to rights. At least one participatory space with the people who are building such policies should be guaranteed. Migration policies, likewise, must take into account the identity of people and children in a situation of human mobility, specifically with respect to indigenous and African descent communities whose worldview is based on principles that differ from those of the nation-states of origin, reception, or transit. Likewise, in order to respond to this structural racism, a response is needed that does not seek to homogenize and Latinize the communities, but rather it is necessary to create public policies that address the more than 150 indigenous languages that exist in the region. It is likewise necessary for states to recognize that racism in the region also has a specific impact on populations that, despite not recognizing themselves as having an identity due to projects of creation of mestizaje, are racialized in a negative sense due to their ethnic racial markers such as phenotype, language, accent, and even their appearance and clothing, whatever the context may be. An ethical political perspective of care and human rights, which implies recognizing the structural and social context of racism that exists and how it conditions the lives of people in a situation of mobility. Likewise, in this sense, we request that the Inter-American Human Rights Commission exhorts states of the region to do the following: recognize the existence of racism in the region, taking into account the diverse nuances of each national territory, as well as its multiple manifestations, and urge states to legislate and create prevention strategies to contribute to the eradication of racial discrimination in Latin America against people in a situation of human mobility. Take effective legislative and/or communitary measures to prevent, address, and protect racialized communities that are forcibly displaced internally in the region. Guarantee the right to interpretation in multiple indigenous languages for indigenous communities in a situation of human mobility that have to leave due to various structural causes, such as the violent conditions of extractivism. Bring sensibility to the importance of creating informative materials in indigenous languages on various procedures and general information, such as family reunification processes. States are urged to fully comply with the guarantees of due process, such as eliminating threats and other intimidation by immigration authorities to sign incriminating documentation or documentation related to expulsion proceedings, eliminate threats and other intimidations, guarantee access without exception to interpreters of native languages and other languages such as Creole, design adequately educational and training programs for all state officials and officers, especially judicial officials and law enforcement, to raise in consciousness of racial prejudice as well as the anti-racism perspective. Evidence of such learning should be a minimum requirement for career advancement. Statistical data related to ethnic racial markers should be disaggregated in censuses and institutional records, mainly in the area of law enforcement, administration of justice, in order to make visible and understand the inequality gaps created by racism. Racial profiling is prohibited in the regulation and legislation applicable to administrative and organic order of police and immigration institutions and authorities, and to reform those provisions of their ordinances that neutrally allow the power to racially profile people. Finally, the use, development, or adoption of digital technologies at the border should cease, at least until adequate safeguards are in place, as the use of surveillance technology systems for migration control purposes that reproduce racist patterns allow racial profiling. Thank you very much.
Thank you very much. Because of the importance of hearing your recommendations, I gave you more time. I won't tell you how much, because I don't want you to feel guilty. So, no, it was too important for me to stop you. I now invite my brother commissioner, the rapporteur of persons in mobility and migrants and refugees and the whole.
Gracias. Gracias. Thank you, Madam Chairperson. I have to start by thanking Promise Institute for organizing this hearing and calling such a representative group of individuals and organizations to address one of the most important key subjects faced by our region. Perhaps the entire humanity is facing this issue, which is the subject of forced immigration of individuals. And here, in such a wonderful presentation, which shows the connection between the racial, ethnic issues and mobility, and human mobility, I also want to express absolute solidarity and empathy to our brothers and sisters, Haitian, Central Americans, Mexican, who have come here to share with us certain histories of how difficult it's been to go through this immigration process. It's unimaginable for many of us to know in detail, to fully know about the suffering, the violations, the difficulties suffered involved in moving from your countries of origin through different states with the sole purpose of reaching a place where they can make a life and enjoy the rights. mainly their socioeconomic and cultural rights. Migration, unfortunately, has this root on racism and discrimination. All migrants, or most of them, when they arrive into a new country, they have to face this incredible challenge, which is racism and discrimination either in the transitory countries or the country of destination. However, we find these multiple type of discriminations when, on top of everything, these are groups, vulnerable groups, like the ones who have addressed this committee. Afro-descendants, indigenous people with a situation that requires special protection. I also want to acknowledge all organizations in the civil society and all the shelters that help migrants, women who in the journey, the migratory journey, approach the migrants, sometimes to offer some food, perhaps the only food they're going to have the whole day, so that they can continue their path. These are humanitarian organizations. These are individuals who are doing the job that many authorities, state authorities in countries are not doing, or they don't have the resources to be able to do. This year is our 5th anniversary of the adoption of the World Pact on safe, orderly, and regular immigration. I fear that when we assess the advancement and the implementation of that pact, that World Pact, that actually generated so big expectations, we're probably going to observe a deficit of all the goals that we had set back then, and I'm talking about 5 years ago. What is it that, what do I understand as the 3 main characteristics of this forced migration in our region? Well, on one hand, we have this migratory flow unequal to any flow in the past. It is a result of the lack of economic opportunities, and also resulting from many other factors that are making people leave their countries because of dangers they face in the hands of organized crime, the lack of safety in their countries, and perhaps, in fact, also the climate changes in our corresponding territories. And here in this region, the Commission has been noticing throughout this process all the migratory flow from south to north and south to south. But what I find as a common place here, and this is a common concern and a pressing concern, this migration that starts from Tapón de Dariel, crossing the entire Central America and Mexico for the purpose of reaching the United States and perhaps Canada. We're talking about mixed migratory movements from people from different national origins. It doesn't only include people from Central America and Mexico. We know that in that migratory flow, there are brothers and sisters from Cuba. The Venezuelan migration continues going to the north. But there's also migrants from other continents who face even greater dangers to reach the American continent and start their long journey. I also notice the absence of a regional accord, which, based on the principle of shared responsibility, would be able to face these challenges suffered by immigration from the different perspectives in the different countries. I really notice the absence that in all these multilateral forums, we don't hear where are the agreements to establish with absolute clarity the obligations of all the states, the original countries, the transitory countries, and also the destination, but also the countries they will go back to. The third element that I want to mention, which we have noticed, is, many of you mentioned this, by the way. Now we have very restrictive migration policies. Title 42, the Remain in Mexico program. We have talked about that here. Yeah, they have been mentioned. And this is just simply a vicious circle, because the greater the migration restrictions, the greater is the danger people face, and also the risk of victimization by migrants in this long journey. This commission has been addressing this phenomenon from their beginning, observing the different tools and implementing different tools we have. They have mentioned the Haitian case here, but I want to mention also that after this terrible earthquake in August of 2021, the Commission adopted Resolution 2/2021 entitled Protection of Haitians in Human Mobility, Solidarity among Americans. This resolution, besides giving visibility to this situation of migrants, it would also call for the international community to actually, with a sense of humanity, address the migratory phenomenon from Haiti. Paragraph 5 thereof, I believe, is very close to what we have heard here. Paragraph 5 says, for the purpose of facing the challenges, protection and challenges of people in different contexts of human mobility, the states must adopt in every action and implemented plans clear focuses, intersectional and intercultural approaches that will allow them to help in the multiple discrimination which increase the obstacles and the risks for the access to rights and enjoyment of rights. The resolution continues talking about how they call the different states in America, but really focus on the Haitian situation that we heard about. We continue living that situation. I want to finish by sharing with you the report about persons in human mobility has been working, and is working right now, on this subject report about mobilization from Central America to North America. The elements you have provided us with during this hearing, and the recommendations, the very specific recommendations you have made to this commission, are incredibly helpful, because yes, this report is part of this general observation. It comes from the observation of what's happening in this region, but it actually requires something, and we obtain the benefit by knowing the details, deep analysis, to be able to understand where do these complex matters stand, and also the importance of viewing these with an ethnic, racial approach, so that we can provide recommendations to the states, recommendations that consider this situation of multiple discrimination. Thank you to all my colleagues for allowing me to extend my time. But I think it has been a great, a very useful moment for this commission to be able to understand, to better understand this phenomenon, a very complex phenomenon.
And Commissioner Hernandez, this is your rapporteurship, and we understand your passionate interest in what happens to peoples in mobility. I now invite the second Vice President, Commissioner Clark, to intervene.
Thank you very much, President Macaulay, and good afternoon, everyone. I want to thank you for your poignant and yet very painful testimony this afternoon. You describe inhumanity, cruelty, savagery that astounds. It's almost incomprehensible, but we have to comprehend it because it is the reality and it is happening. And I thank those of you who gave that personal testimony and had to relive that trauma, and understanding that there are others who are going through that trauma as we speak. You make the case very compellingly of the anti-black racism, the anti-brown racism, the anti-indigenous peoples racism, which in fact is the foundation story of this region, so we call Americas and the Caribbean, and that racism infuses almost everything, and no wonder it also affects disproportionately persons who are most vulnerable, particularly at the intersections of that vulnerability. And I want to note those who spoke about the sexual violence, that's also very much a feature of the human mobility as people move, seeking better circumstances, but really ending up in very much worse circumstances than the ones that they left. I think you outlined very well your main recommendations, and I don't want to go into that, but I think that there's one area that perhaps the Commission, we have to think a little bit more about, and maybe we have already, Commissioner Hernandez, which is how do we strengthen the guidance and support states to particularly address the question of violence by non-state actors. The accountability for state actors is quite clear. Border officers, security officers, health, education, that's pretty clear. But how do we define and describe what is that accountability for non-state actors? What do we expect the state to do in relation to surveillance to make sure that it interrupts before it happens, non-state actors taking control of persons, taking advantage of persons in the course of mobility? I think you spoke about the cross into the Darien region, which can be quite unregulated. State actors may not be in there, but we know that people are crossing the Darien region. What is the expectation of the state in that space to be ahead of and prevent this extreme exploitation? So I think that's something that we need to think a little bit more about. And also it's not for this hearing, but there's no doubt that we're not going to get to the end of the migration, let's call it crisis, the people in movement crisis. I don't want to call it migration crisis, the people in movement crisis, unless we start to also think about inequalities within and between states, which is the thing that's driving people to leave where they don't actually want to leave. That's their home. That's not what they want to do, but they're forced to do that for a better way of life, which all of us want for ourselves and for our families. So I think that these are complex questions, but we can't really, Special Rapporteur on economic, social, cultural, and environmental rights, they're not really things that we can really separate if we want to get to a comprehensive solution. So I want to stop there, but thank you very much for your testimony.
Yes, I now invite the Special Rapporteur on Economic, Social, Cultural, and Environmental Rights to speak. Soledad Garcia.
Thank you, Madam President, and congratulations to you and Madam Vice President for the recent election. I will speak in Spanish.
Very quickly, I'd like to thank you all so much for each one of your testimonies, for your stories and all the suffering that you shared with us in this hearing. This hearing is very important also for the rapporteurship that is in charge of economic, social, cultural, and environmental rights, especially through these goggles of anti-racism that you have helped us put on as well for the Commission and the rapporteurship. And we have a strategic line of a mandate regarding human mobility, IVESCA, because in these years of work and working very closely with the rapporteurship and with Commissioner Hernandez, it has become very clear how the lack of respect and guarantee of these rights, these ESCER rights, affects all people in mobility and at every point of the way, from the places they leave to places of transit and destination points. So via this announcement, and those of us who are working here in Redesca, a report on poverty, inequality, and climate change in Central America and Mexico with a perspective of human mobility. There's a questionnaire currently through which we are seeking information with which, and I will put it on the table. I have two concrete questions now. One, because in Redesca, in the rapporteurship, we are especially concerned with the situation of those who live on the street. In fact, beforehand, we had the support of the Institute to visit Los Angeles, and we observed and we received many testimonies of people who are in mobility, who are fleeing sexual violence, who have been seeking a better destination, are living on the street. This information would be very useful for our commission. The situation of individuals without a home, and a specific question for Alma: what type of work should be done in the cooler, as I understood it? What kind of work has to be done to earn that dollar and be able to eat fruit?
I now invite the Executive Secretary, who says she'll speak briefly.
I just want to thank so much everyone for these testimonies of colonialism, of dehumanization so clearly. I would like to mention how the racial profiling puts people in the focal point of police and immigration control. And I think the testimonies you shared with us about intersectionality between immigration, gender, and racial profiling is so helpful, and the way that women are re-victimized and migrants by being made invisible and not having their stories believed. I believe it's so fundamental and important to have this hearing in a space where we begin with the idea that what is being said here is true. We don't begin with the assumption that when someone is before an immigration authority, there's this assumption that what someone is saying is part of this question or the lie that they assume about people for migrants. I believe Commissioner Hernandez, the rapporteur for migrants, has been quite eloquent about our upcoming steps, but I would like to also recognize Promise Institute for promoting this hearing, for putting it on the radar, for filling this room with all of these testimonies and stories, and we will certainly continue to work with you in relation to our upcoming report, to have testimonies, to have evidence that will be quite useful to us. Thank you so much.
Muchas gracias.
Thank you very much, Chairperson. Honestly, after hearing the rapporteur, the thematic rapporteur, and the commissioners, I can't say so very much, but I would like to just emphasize the importance of this thematic hearing for the purposes of the reports that the Commission issues. We have sources of first and second hand. Hearings are a first-hand source, an extremely valuable one for the hard data that you bring us and the testimonies that are so important. Overcoming fear, timidity, and anguish, and daring to present to the Inter-American Commission of Human Rights your personal experience. We thank you so much for that, because it enriches the work that we do on a technical level in the Executive Secretariat, and it commits us as well to give a response, a very serious response. So we will be doing follow-up on this to receive all of this data and information to enrich our report that the rapporteur has just announced. Thank you, and thank you, Madam Chairperson.
Take a couple of minutes to close. Because we have to close the session now. We should have closed some time ago. But as I said, this is extremely important. And I first want to thank you for your very structured presentations, which were so rich in content, full of the baseness that human beings in power can create for others. And the various ways that persons in mobility suffer the rigors of the utmost terror, fear, discomfort, the fear of dying slowly in jungles and being bitten by insects that eat your flesh. I saw that. I saw that. We saw that when we went to border towns to visit. And we were supposed to continue to do these visits, to meet these people in the so-called detention centers. I don't use that term, I use so-called, because they are prisons. And we must not give them the level of calling them detention centers. Put them where they belong. They are prisons. We went there. We saw people within such institutions, spoke with them, interviewed them, found out what they ate, what they drank, and so on. And when they're sick, how they were treated. We went to the so-called courts as well. And I am a lawyer. I've been a lawyer for longer than some of you have had breakfast. And believe you me, I would not call that a court. I would not call the person presiding a lawyer, let alone a judge. But there were. And you were right. The people before them couldn't understand the word that was being said to them. And some of the people were toddlers of 3 or 4, put in a big chair, and the judge directs the statements to that person, little person. I have never been so disgusted in my life. And I happened at one period, Maria Claudia, you'd remember, I was rapporteur for migrants as well for a space of about 5 months. In addition to my then women's rights rapporteurships and Afro-descendants. Now I'm Afro-descendants and for elderly persons. And my Afro-descendant rapporteurship is also against racism. And this region, as my sister has said, is replete with it. And one wonders, because the region is full of immigrants. Every single person who's not indigenous to this region is an immigrant. And yet they're the ones in power, and they're the ones keeping other persons who wish to emigrate, and not only wish, who are forced to, out. Now, if I'd stayed in that rapporteurship, I probably would not have survived in the commission so long, because it is too painful. It's too painful. And so I understood everything you're saying. It brought the pictures to my mind. So I ask you, please, could you send all those recommendations to us? I couldn't even take a tenth of it because my hands couldn't write properly. And please supply us with any information and documents that you have, so that we can further the work of my brother, Commissioner, who is so passionate about the work that he has to do for persons in mobility. I thank you all for your presentation, and thank you for coming to listen to what was said here today. Yes.
Muchas gracias.
Thank you very much, Commissioner. We will try to be very brief.
To have a short participation right now, just having some remarks.
It has to be very short because we have another.
Sí, solo vamos.
Yes, we are just going to answer 3 questions, Alba. Yes, the issue of working for just $1 for a few hours, that was to obtain fruits, which was the basic issue, because as I mentioned when I read that from the sheet, we were given food that was frozen and was expired. That's why. We also wanted to talk a little bit about what was already mentioned, is how shared responsibilities but differentiated responsibilities are impacting the criminalization of the migration policies. During these past years, we have observed the restriction in the access to rights. Sometimes the responsibility is shared, and it translates into countries that cannot provide guarantees to people from beyond the continent, such as refugees from Africa. They must stay in other countries that also do not have safe conditions for survival. So we wanted to emphasize the fact that these policies, while they will be beneficial, must clearly It should clearly be observed that states or countries can respond with rights. It is also important to note that many of the states in the region do not have legislation that considers structural causes of human mobility. That is to say, these racialized communities that are forced to leave, their state of origin does not respond at this time. In Central America, very few countries have laws that respond to forced displacement internally. Also, finally, regarding racism, complementing a bit the ideas that were expressed.
Really sorry. Please submit it to us in writing.
Perfect.
We really can't because we have more than one session on our agenda for the rest of the day. So please, just send it to us in writing. This normally we do not allow at all for some people, right? But you did have a say. So we have to close now. I'm really sorry. But please send us the information. This session is at an end. Thank you very much, all of you.
The path to business success.